Yeah, please, your lordships.
Yes.
Lordship, I beg to mention item number 74. 74 in the hearing list. Lordship, in this case, the state government has filed an act.
74. There is no 74.
Oh, sorry, Lordship, it seems a new costless is done. Lordship, yes, item number 43. Lordship, the copy I have is a different. My lord, in this case, Lordship, the state government, when the matter was heard before the learned single judge, the state government had filed Lordship on the basis of a written instruction. The case was decided. And at that moment of time, it was the categorical stand of the state government as reflected in paragraph 3 that they will not file affidavit for a letter single bench. But in the present writ appeal, the Advocate General is appearing and they have filed an affidavit, which I received last week. So, my lord, after going through that, even if I need to file a reply to that.
Okay.
So kindly give me, Lordship, may kindly grant us 2 weeks' time to file a reply to the affidavit filed by the state government.
Yes.
Lordship, then in that case, matter may be listed after 4 weeks. AG will be appearing.
No problem,
this
Lordship,
matter.
because Madam Justice Wild Longomere cannot take up this case, so no problem. We can fix a date. In the meantime, I can file.
Heard Mr. Takamasha, learned senior advocate appearing for respondent number 1, 1 to 4, 6 to 32, 34 to 89, 96 to 91 to 96, 98 to 100, 102 to 124, who prays for some time for filing a reply to the
Affidavit filed by the
affidavit filed by the
state respondents.
state respondent. The prayer is not opposed to by who is for the appellant?
I'm for the appellant.
Prayer is not opposed to by learned counsel for the appellant as well as learned additional advocate general. Hence, same is allowed. Let this matter be listed after 4 weeks.
If Lordship kindly give us a date, since AG is appearing, it is better. we-
9th September.
9th September.
After 4 weeks, if we, Lordship kindly give us a date.
9th
after-
September.
Lordship. 9 September,
Is it okay?
yes.
Let this matter be listed again on 9th September.
Lordship. Also, Lordship, I beg to mention item number 39 and 40 in the same hearing list. Lordship, it will take this, even if it reaches, it will not be possible for an effective hearing. It will require at least minimum 3-4 hours of hearing. So it's a consensus prayer that the matter will be listed next week. Even if it reaches, it will not be possible for an effective hearing. Lordship.
On request of learned counsel for both sides, let this matter be listed
Next week?
Next week.
After.
after a week on a date to be fixed by registry.
My please lordship, lordship, I beg to mention item number 29 is for order, your lordship. Now, I pray that the matter will be listed for hearing next week, your lordship. For order, parties are represented, your lordship. Because this is a matter which cannot.
Why it has been listed in orders column?
Order because earlier occasion parties were not represented.
So it
Now-
is ready for hearing.
Yes, your lordship.
Heard Mr. T.B. Jamil, learned counsel for the appellant. Also heard Miss
Kitty Imjen.
Katie Imchin, learned counsel for the respondent. Anybody else is
The
missing?
state, Lordship, state.
Also heard
It is
Mr.
respondents of the.
Nangami, learned senior government counsel appearing for the state respondent. It is submitted at bar that this matter is ready for hearing. Hence, list this matter for hearing on 12th of August 2026.
Obligement.
Obligement.
So, Lordship, I beg to mention item number 31. This matter be listed tomorrow, next week. I'm for the appellant.
heard Mr. Yangarwati, the learned counsel for the appellant, who prays for listing this, who prays for an adjournment today. You have informed the other side,
Yes, Lordship. I'm very good respond on the petition.
the learned counsel for the other side has not opposed to the
Yeah,
prayer.
next week.
Hence, let this matter be listed again on 10th of August, 12th of August, 12th August, next week.
Okay.
May please, my lordships. Lordship, I beg to mention item number 4. 4, 5, 6, 7. Lordship, item number 4 is has a separate judgment order. So this item number 4, that is writ appeal 44 2025, may be segregated from the rest. And Lordship, there is a break at item number 8, but this 5, 6, 7 and the next 9, 10, 11 to 17 are analogous. So Lordship, this also can be clubbed up together along with the first 58, along with 5, 6, 7, 8, there is a break. 8 is another.
5, 6, 7, 8, and
5, 6, 7, 9 to 17. They are all analogous matter. Same judgment order.
8 is different.
Yes, 8 is,
8 and 4 is different.
and 4 may be segregated, though all the same, the order is different. So 8 may be separated from 5, 6, 7, and 9 to
The 8
17.
is already separate, already listed differently. So 4 has to be segregated. And,
Only 4 has to be
and
segregated.
5, 6, 7,
9
9 to
to 17, all analogous, Lordship. And
why these are listed today in orders column?
Lordship,
Admission column.
that I'm not aware, Lordship.
it's
So-
in the admission.
Yes, Lordship.
You are praying for fixing these matters on some other day after segregating.
Yes, after segregation. And also in writ appeal 44, we file an amendment writ petition, and inadvertently I found out there is a slight inadvertent mistake in it, so I have to check out in writ appeal 44, 2025.
Right in writ appeal in item number. In item number 4, heard Miss Z. Zimomi, learned counsel for the appellants. Also heard Mr. Joshua Sheki, appearing for respondent number 33. My lord, who else is appearing? Who is for the government? Also heard
Yes.
Miss V.
Lordship, Vizimo is appearing in this case, Vizimomi.
In 44, writ appeal 44, B. Jimomi is appearing.
V. Zimomi, learned government counsel, senior government counsel.
Junior government.
Learned government counsel appearing for the state respondent. It is submitted by learned counsel for the appellant that this appeal has been clubbed with writ appeal number 45/2025 as well as writ appeal number 54/2025. However, as this appeal arises from a different order, different judgment, same needs to be segregated from the said writ appeals. The prayer is allowed. Registry to segregate this writ appeal from WA 45/2025 and WA 54/2025 and list the same for admission after a week on When do you want?
After,
Let it be up to 2 weeks.
After 2 weeks. In item number 5, you write. So,
5, 6, 7. And
9 to 17.
9 to 17, yes.
5,
in the
6,
latest
7,
matters.
9 to 7. Not so and so, write the name of the council. This writ appeal. The writ appeal number 45/2025 and writ appeal number
51.
54/2025 was earlier clubbed with writ appeal number 44/2025. However, by an order passed today by this court in WA 44/2025, these two writ appeals are segregated from the aforesaid writ appeal stuff. The writ appeal number 45/2025 as well as
54,
54/2025 may be
58.
clubbed with writ appeal number 58/2025,
then 51,
writ appeal number 51's 2025, 52,
52.
2020, 25, 53, 2025, 55, 56,
57,
57,
59, 59,
59, 60 and 61. And maybe
Lordship.
this,
58, busy.
yes,
There is also another writ petition 58, Lordship. It's not listed here.
and
Oh, okay, okay.
where,
It's in item number 7, Lordship. I beg your pardon. Yes,
and be listed for admission after 2 weeks on a date to be fixed by this. Motion.
obliged, Lordship. Even 44, they can list out together, except segregation.
44, I have passed separate order. After segregation, it will be listed after 2 weeks.
Oh, yes, yes, Lordship. Obliged, Lordship.
Wait, bless your lordships. Lordships, I'd like to mention item 42. I am for a state here.
Yes,
I pray that this matter may be listed next week. That is on 12th, next Wednesday, coming Wednesday.
you have informed the other side.
Yes, yes.
Heard Mr. Moim Chenlanet, Senior Government Counsel, appearing for the state
Next
respondent,
week,
who prays for listing this matter on 10th of August,
12th.
12th of August. The prayer is allowed. List accordingly.
Very good. Public.
May I please your lordships, I beg to mention item 23 to 25 on behalf of the CJSC. The learned CJSC is in dispose, so if this matter can be listed next week.
Rovi,
Yes.
heard Ms. Rovi Sukru, Learned Counsel for the appellant, 23 to 25, separate orders, who prays for an adjournment on the ground that the Central Government Council is indisposed. Also, Mr. T.B. Zamir, Learned Counsel for the respondent, who does not raise any objection to the prayer. Hence, the prayer is allowed. Let this matter be listed next week.
Next week, Lordship, because this is a matter which cannot be taken up by justice by long.
Okay, let this matter be listed on 12th of August.
On 12th. And
Right.
Lordship, I beg to mention item 22 In this case, item 22, your lordship, read appeal 25 of 2026. In this case, I have instruction to appear on behalf of respondent number 4 and 5, your lordship. So I pray that the matter will be listed after 3 weeks, your lordship.
I have no objection.
Heard Ms. Lushino, learned counsel for the writ appellant. Mr. T.B. Zamir, learned counsel for the respondent number 4 to 5 has submitted that he has been instructed to, you have filed wakalatnama?
No, your lordship.
He has been instructed to appear on behalf of respondent number 4 and 5, and he would be filing his wakalatnama very shortly. As such, he prays for listing this matter on some other day. The prayer is allowed. Let this matter be listed after 2 weeks.
Obligation.
Lordships, I also beg to mention item 32, hearing item 32. With the consent of the opposite party, if this can be listed after 2 weeks,
32.
yes. For the appellant.
I'm for respondents 2 and 3, lordships. I have no objection.
Heard Ms. Krovi Sukru, learned counsel for the appellant, who prays for an adjournment. Mr. Sentianger, learned counsel for the respondent, does not raise any objection. Hence, the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Lordships.
May I please, my lords? Lordship, I beg to mention item number 33 and 34. Lordship, I've filed adjournment slip yesterday also. Lordship, I have some difficulty today, so.
Heard Mr. KV Angam, learned public prosecutor, who seeks an adjournment on the ground of personal difficulty. The prayer is, you have informed the others, appellant.
Lordship, if it can kindly be fixed on 19th of
Oh,
August.
yes. Mr. Sentianger, learned counsel for the appellant, does not raise any objection. Hence, the prayer is allowed. Let this matter be listed
19/8.
on
2000.
19/8,
Yes, my lord.
2026.
Like your lordships. Lordship, I also beg to mention item number 46. I have some difficulty, so if it may kindly be listed after 2 weeks, lordship. I've taken the consent of the other party, lordship.
Heard Mr. KV Angami, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty. Also heard Mr. M. Vero, learned counsel for respondent, who does not raise any objection to the prayer made by the learned counsel for the appellant. Hence, same is allowed. Let this matter be listed after 2 weeks.
Like your lordships.
Mr. Lordship, I beg to mention from the order, item 30,
1330.
Your Lordship. Your Lordship, this matter is listed for hearing, but this matter may kindly be taken up on Thursday, next week, Wednesday.
Heard Miss Ina Holly, learned government counsel, appearing for the respondent, who prays for a short accommodation and listing this matter on 12th of August. Mr. W. Marhu, learned counsel for the appellant, does not raise any objection. Hence, the prayer is allowed. List accordingly.
Like, Your
Obliged.
Lordship, I also beg to mention item 35, Your Lordship, on behalf of my colleague V. Jimo. He has taken the consent of the other parties. This matter may kindly be listed after 2 weeks. Item 35.
Heard Miss Ina Holly, learned government counsel, appearing on behalf of Mr. V. Zimomi, learned public prosecutor, who prays for an adjournment on the ground of personal difficulty. Also, Mr. Toshio Longkumar, learned counsel for the appellant, who does not raise any objection to the said prayer. Hence, same is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Your Lordship, a similar prayer for item 37 on behalf of V. Jimo.
37, same order.
And your lordship, item 44, on behalf of S. Mary, this matter may also be kindly listed next week, Wednesday. Item 44.
Heard Miss Hina Holly appearing on behalf of Miss S. Mary, Learned Government Council, appearing for the responding, who prays for an adjournment. The prayer is not opposed to by Learned Council for the appellant, and same is allowed. Let this matter be listed on 12th August,
Lordship, 12th of,
12th of
see, lordship, much obliged, your lordship.
Obliged, your lordships. May I please, lordship, I beg to mention item number 8, my lord. Lordship, I have instruction to appear for respondent number 2, 4, and 5, my lord. So if 3 weeks time may be granted to me, my lord, to find my Vakalatnama and to seek instructions.
I have no objections, lordships.
heard Mr. Senti Angel, Learned Council for the appellant. Also heard Mr. M. Vero, Learned Council, who submits that he has been instructed to appear on behalf of respondent number
2, 4, and 5.
2, 4, and 5, and he would be filing his Vakalatnama shortly. And as such, prays for listing this matter on some other day. Prayer is allowed. Let this matter be listed after 2 weeks,
3 weeks, my lord.
3 weeks, on a date to be fixed by the
Lordship,
Much obliged, lord.
in items 26 and 27, the learned DSGI is appearing from, he's based in Gauhati. And due to the weather conditions and the flood problem, the road problems, lordship, he was unable to come as such. A request is made to list the matter again on 16th of September, my lord.
Heard Mr. Senti Younger, Learned Council for the appellant, who submits that the Learned Deputy Solicitor General of India, who is stationed at Gauhati, is appearing in this appeal. However, due to bad weather condition, he could not make it to Kohima today, and as such, prays for listing this matter on some other day.
On
The prayer is
16th,
that
9, 16th
let
of
this
September,
matter be listed on 16th of September,
my lord.
2026.
I am deeply obliged, my lord.
26 and 27.
My lord, my lord.
Okay.
Deeply obliged.
My pleasure, Lordship. Lordship, I beg to mention item number 18.
1-8.
Lordship, on behalf of additional AG in Team Song. Lordship, may kindly list this matter after 1 week.
My lord, let it be next week. Let it be next week. There's an urgency in the matter. I have had a discussion with the regional AG also. Let it be next week.
Heard Miss Pichano, Learned Council, appearing on behalf of
In Team Song, additional
Mr.
AG.
Imti Imsong, additional AG, who prays for an adjournment. Also, Mr. Takamasha, Learned Senior Counsel, appearing for the appellant, has no objection provided the case this appeal is listed in the next week. The prayer is allowed. Let this matter be listed on 12th of August.
Lordship, item number 45. A similar prayer, Lordship.
The same order is in place of Mr. Takamasha, write the name of Muazzamir. Remaining order remains same.
Lordship, item number 49 as well.
Heard Ms. Pichano, Learned Government Council, who prays for an adjournment. Mr.
V. Koza, lordship.
V. Koza, Learned Council for the appellant, does not raise any objection, hence the prayer is allowed. Let this matter be listed.
Lordship, if you can be on next week, lordship.
Next
Yeah.
week, we have fixed lot of cases. Again, same scenario will be there. So we are fixing it next to next week,
Lordship.
Lordship.
next week. That is on,
19.
next to next week is
19.
19 August. Lordship.
19th of August. 19th of August.
I pledge lordship.
Much obliged.
For motion, item number 1.
May I plead your lordships? Lordships, I am appearing on behalf of the petitioner in the instant matter. Your lordship, the instant matter pertains to the detention of the petitioner detainee under the NSA. So, your lordship, by this instant writ petition, the detainee is challenging the impugned detention order dated 19/01/2026, passed by the Commissioner of Police and District Magistrate Dimapur, as well as subsequent impugned orders
Yes,
approval.
Ms. Naholi, you are appearing for the response.
Yes, for 1, 2, and 3.
You'll be filing your
Yes.
notice issue. Mr. What is your name?
P. Suren lordship.
P. Suren, the learned council
For respondent notary ma.
for
That can only.
learned council for the petitioner. Also heard Mr. Z. Enguli. Miss Ina Holly appearing for respondent number 1, 2, and 3, as well as Mr. Z. Engoli, learned Central Government Council.
Yes.
Appearing for respondent number 4. This writ petition under Article 226 of the Constitution of India has been filed by the petitioner. Shri Inoka Aimi, his brother Bosheto Aimi, impugning the detention order dated 19/1/2026, passed by the Commissioner of Police and District Magistrate Dimapur under Section 3 within bracket 3 of the National Security Act 1980. Let the notice be issued, since all the respondents have been represented by their engaged counsel. No formal steps for issuance of notice need to be taken. However, you have received the copies.
Oh, your lordship.
However, the petitioner shall furnish copies of the writ petition along with the requisite numbers of copies of the writ petition along with the annexures to the learned counsel for the respondents within a period of 2 days from the date of this order. Learned counsel for the respondents prays for some time for filing their affidavit in opposition. How much time?
3 weeks, your lordship.
Some time for filing their affidavit in opposition. The prayer is allowed. Let this matter be listed after 3 weeks on a date to be fixed by this. You give a date after 3 weeks.
Lordship, as per the
26
of the
August.
26th
26 or 2nd September.
26th of August. List accordingly.
Obliged.
obliged lordship.
For admission, item number 2.
May I please your lordships? My lord, in this Sumudu PIL, lordship, on 3/6/2026, this honorable court has directed the NHIDCL as well as the chief engineer, respondent number 5, National Highway Nagaland, to file affidavit. However, lordship, the copies of the affidavit in affidavit filed by the respondent number 6 and 7, that is the NHIT still I received yesterday. Now with regard to the affidavit filed by respondent number 5, just received inside the courtroom. So my lord, to properly assist the court, this I need
To
little
go-
time to go through it.
Okay,
So may I pray that the matter may be listed next week or maybe a little bit on 19?
okay, we are fixing it on 19. Third, Mr. Takamasha, learned senior counsel, as well as amicus curiae, assisted by Mr. What is your name?
Sandy Long.
Senti Long, learned counsel for the petitioner. Also, Mr. Imti Imsong, learned additional AG, appearing for respondent number 3, 4, and 5, as well as Mr. Muaz Amir, appearing for respondent number 6 and 7. It is submitted by learned amicus curiae that that in pursuant to the order dated what
3/6.
3/6.
3/6/2026.
3/6/2026, the respondent number 6 and 7 have filed their affidavit. He also submits that respondent number 5 has also filed affidavit. However, he has received the copy of the same yesterday only.
No, this morning, Lordship, inside the courtroom.
This
filed by
morning
5.
only, and needs some time to go through the same so that he may be in a better position to assist this court. The prayer is allowed. Let this matter be listed again on 19th of August.
Pledge.
Item number 3.
Yes. Mr. Yangarvati. You have not rectified the defects.
I have
Yeah.
rectified, Lordship. I have rectified. So this is come for.
When you have rectified.
Pardon? The petition has been rectified, Lordship. And this is the request, we will say the request petition, Lordship. Lordship, I have a very limited ground here, Lordship. I'll be allowed to read from section page 5 of the read bill. Part 2. You got it, Lordship?
No, just some documents which were not legible. Have you replaced those documents?
Lordship, here we are not concerned with the annexures. We are only concerned with the selection process, Lordship. No, it's most of the annexures are not relevant. Like for example, the birth certificates, these are not relevant.
We're not getting it. What are you saying?
Pardon?
What, we are not getting it. What you were saying? What are you saying?
We were asked to recast the petition.
Yes, because
We have already recast,
there are
Lordship.
many documents which are not releasable.
Yes,
We have replaced it.
We are not interested with the annexures, Lordship.
Then why have we annexed this documents?
Because this is necessary, Lordship, because we in the appeal.
So
because in the
if we have put certain things as annexes, then those have to be legible.
this we have already rectified, Lordship. We have already
No,
rectified.
but there was a direction of this court on 24/6/2026 to
6.
rectify the defects
But
And there is a office note that you have not done so. You have not, those illegible documents, you have not changed it.
Is it important? My lordship, can I see the, not that 20, order that 24/6, which your lordship is mentioning?
you were not there when the order was passed. You were not there when the order was passed.
No, I was here, lordship, I was
That-
here. Lordship, I have already rectified, that is why the writ petition has come
Because the
from,
office note says that it was not, it hasn't been rectified.
yes.
So you need to carry out those rectification work.
Then the lordship, that come up next week, I will rectify all the, any defects. If there is any defect, I'll rectify it.
Just find it out. And maybe there are certain pieces which are not legible.
Mhm.
So
Yes,
court is of the view that those things should be rectified.
Yes, sir. I'll call to the court's record, lordship, and if there is any rectification to be done, then I'll do it within a week. So let this come up again next week.
Actually, your lordship, I have a small submission to make, your lordship. Because of the pendency of this writ appeal, your lordship, the contempt proceeding
letter.
which has been filed, that is, there's an order for listing the contempt petition after disposal of the appeal, your lordship. Now, similar matter in contempt petition, the affidavit in opposition filed by respondent is there, the SLPs on similar matters are pending, your lordship. Even those SLPs has been dismissed, your lordship, prior to filing. of
Grounds are
this
different,
appeal.
lordship. Grounds are different.
Filing of this, prior to filing of this appeal, your lordship, but that has not been even mentioned, your lordship. So if connected matters, SLP has been dismissed, I have got the order, your lordship. But because of this, even and it's more than 2 years now, the judgment order has not been complied with, your lordship. Now, if next week they say they will do it, it's okay. Otherwise, your lordship, because in spite of the direction passed by this honorable court, rectification has not been done. So more than a month. your
On this, on that ground, the appeal should be dismissed.
lordship. On next date,
Next date,
at
then-
next date, a week's time may be given as last chance. As last chance, your lordship.
In fact, lordship, I'm also very difficult position.
Heard Mr. Yangarwati, the learned counsel for the appellant. Also heard Mr. T.B. Zamir, learned counsel for the respondents. It appears that by order dated 24/6/2026, the appellant was directed to rectify the defects, completely rectify the defects which were pointed out by these courts. However, office note dated 19/6/2026 shows that in spite of being informed, the counsel for the appellant declined to carry out the necessary rectification and changes which were required in terms of order number 19 dated 2nd April 2025 issued by the registry of the principal seat. Mr. Yangarwati seeks a week's time to go through the record and take necessary steps for rectification before the next date fixed, and prays for listing this matter in the next week. The learned Mr. T.B. Zamir, learned counsel for the respondent, submits that only because of the pendency of this writ appeal, the contempt case filed by the present respondent / writ petitioner is still pending. He further submits that in similar matter, the
SLP.
Union of India had preferred SLP before the apex court. However, same has been dismissed. Stop. Considering the submissions made by learned counsel for both sides, some time is granted to the appellant to rectify the defects in the memo of writ appeal and the annexures thereto. List this matter again on 12th of August 2026.
Failing which appeal should be dismissed, your lordship.
On that day, it is further clarified that no further chance shall be given to the appellant to comply with the directions of this court. List accordingly.
Deeply obliged.
If I am be allowed to mention, item order dated 22/7/2006. It says that next week, lordship, next week.
You just go through it.
Yes.
If there are something, because earlier the defect was that the pleadings were not there.
Yes.
I think pleadings you have brought in. So
Thereafter,
again, that
legit-
there's some problem with
Yes.
the.
I'll take the records, lordship, and
List accordingly on 10. 12.
yeah.
For admission, item number 19.
Lordship, if I may.
Yes.
Your Lordship, the petitioner is the wife of the detainee, Your Lordship. And the petitioner decides to set aside the detention order, impugned detention order dated 19th of November 2025, Your Lordship.
Dated 19th of
November 2025. Your Lordship, the fact of the case is that, Your Honor, on 21st of October 2025, the detainee was arrested based on the complaint received from the 13th Assam Rifle, COB, regarding trafficking of arms and ammunition from Dimapur towards Suruhuto camp, Zonoboto, during MVCP around Chetabatam. Thereafter, Your Lordship, the case had been registered at Chozova Place, case number 4 of 25, under section 308 clause 2, 3 clause 5 BNS, read with section 25 1A, 27 clause 2 Arms Act 1959, read with section 7 and section 8 of NSR, Your Lordship.
what is NSR?
NSR, Your National Nagaland Security Regulation, Your Lordship.
Yes.
Yes, Your Lordship. Thereafter, Your Lordship, from the day of his arrest, the detainee was kept under custody, police remand, for 5 days. While the detainee was in judicial custody, the superintendent of police had made a proposal for detention dated 4/11/2025, Your Lordship. Your Lordship, we have next at Annexure 6, Your Lordship, page number 58 of the petition, Your Lordship. Thereafter, Your Lordship, the respondent number 3 had passed the impugned detention order dated 19th of November 2025 in exercise of the power under section 3, clause 1 and 2 of the National Security Act, Your Lordship. The detention order is annexed
National
at
security.
page number 71 Annexure 7, Your Lordship. May I read, Your Lordship?
Page numbers?
71, Your Lordship, Annexure 7.
Yes.
Your Lordship, the order, whereas Sri Moase Pune Hakun, NSCNK Nikki Group, son of Thome, resident of District Tirap, Arunachal Pradesh, was arrested on 21st of October 2025, along with 4 others, when proceeding towards Zonabodha district, acting as an escort for arms and ammunition being carried in white Maruti Gypsy bearing number so-and-so, in connection with Chosova PS case number so-and-so, under section 308 clause 2, 3 clause 5 BNS, read with section 25(1)(a), 27 clause 2 Arms Act, read with 7 and section 8 of NSI, Your Lordship. And whereas I, the district magistrate Peck, after examining and studying the facts, evidence, and police report of the case, satisfied of the ground with the view to Sri Moase from acting in any manner prejudicial to the state and maintenance of public order in the state, threatening the peace, security, and transporting of arms and ammunition, and for the maintenance of public order in the state. It is expedient to detain him under subsection 1 and 2 of the section 3 of the National Security Act. Now, therefore, in exercise of power conferred under section 3 of the said Act, I, the district magistrate, hereby order that Sri Moase Pune Hakun be detained and kept in Central Jail, Chimukidima, Nagaland. Your Lordship, when the impugned detention order was passed, the detainee was under judicial custody, Your Lordship.
Yes.
And the detention was cuffed against while he was under the judicial custody, and while passing the impugned order, it did not mention the fact that the detainee was already in custody, Your Lordship, and has reasons to apprehend that the detainee is likely to be released on bail, Your Lordship. So this facts being non-existent, Your Lordship, the impugned detention order was passed, and upon the plain reading of the impugned order, it shows that none of these mandatory satisfactions were recorded, Your Lordship. The order is completely silent about the existing custody of the detainee, the likelihood of his release on bail, and the necessity of the detention despite such custody, Your Lordship. This omission, Your Lordship, it violates the subjective satisfaction, Your Lordship, and it renders that the detention illegal, Your Lordship. Your Lordship, in regard to my submission, a reference
So 3 things. One is likelihood of releasing on bail is not mentioned.
not mentioned, Your Lordship.
So,
Not
and
mentioned.
then the judicial
being in custody as
immediate
well.
custody was not mentioned.
Not mentioned, not mentioned.
Therefore, subjective satisfaction is not there.
It's not there, Your Lordship. So in support of the submission, Your Lordship, I'm placing a reliance on the decision passed by the Honorable Court in Khudiram Hanjao Singh versus the State of Manipur, 2012, volume 7. Paragraph, Your Lordship, para 9, page number 4, Your Lordship. Your Lordship, if I may. Page number 4, para 9. May I read, Your Lordship?
Yes.
In view of the above, it can be held that there is no provision in the law to pass the detention order in respect of a person who is already in custody in respect of a criminal case. However, If the detention order is challenged, the detaining authority has to satisfy the court the following facts. Number one, the authority was fully aware of the fact that the detainee was actually in custody. Two, there was reliable material before the said authority on the basis of which he could have reasons to believe that there was a real possibility of his release on bail. And further, on being released, he would probably indulge in activities which are prejudicial to the public order. Number three, Your Lordship. In view of the above, the authority felt it necessary to prevent him from indulging in such activities, and therefore, detention order was necessary. In case either of these facts does not exist, the detention order would stand vitiated, Your Lordship. Further, Your Lordship, while the detainee was under judicial custody, Your Lordship, and when the detention order was passed, and the approval order was also passed, and before he was produced before the advisory board, all those relevant documents supplied to the detainee were all in English, Your Lordship. Here, Your Lordship, the detainee is a person who is a resident of Arunachal Pradesh. He belongs to Nokte tribe, and the only languages known to him is Nokte, Hindi, and Nagamese, Your Lordship. Your Lordship, if I may take the Honorable Court to the page number 42, annexure 4, Your Lordship. At serial number 6, serial number 68, Your Lordship. The
Serial number 6.
page number, point number 8, serial number 6, 8. Caste and tribe. It is mentioned Nokte, Your Lordship. That is his tribe. Further, Your Lordship, if I may take to the page number 48, which is a typed copy. Point number 9, serial number 13. Serial number 13.
Serial number 13.
Yes, Your Lordship. Point number 9, serial number 13, page number 48. Language and dialect.
Page 48.
Page 48, serial number 9, point number 9, sorry.
9 is physical features and
Yes, Your Lordship. At point number, serial number 13th.
Huh? Serial number 13.
Yeah, table. There is a table. Column number 13.
Column number 13. You say.
Yes, Lord.
We are saying serial number 13.
My
Okay,
apologies.
Nagamese, Nokte, and Hindi.
Nagamese, Nokte, and Hindi. These are the only 3 languages he is known.
Mm.
So, Lordship. If I may, Your Lordship. So all those copies supplied to the detainee with in a language which he does not understand. And it is an admitted fact, Your Lordship, that the detainee does not know English with all the relevant documents that has been annexed. And in support of the submission, Your Lordship, I am making a reliance in the case of Lalubhai Jogibhai Patel versus the Union of India. Para number 3, page number 10. The last page of the judgment.
Remember?
Para number, page number 10, para number 3. May I read, your lordship, the relevant paragraph?
Paragraphs are not numbered. So in page 10.
Page number 10, second paragraph.
Second paragraph.
Second paragraph.
Yes.
Contention number 3.
Contention number 3, your lordship.
Yes.
May I read, your lordship?
Please read.
It is an admitted position that the detainee does not know English. The grounds of detention which were served on the detainee have been drawn up in English. It is true that Shri, the police inspector who served the grounds of detention on the detainee, has filed an affidavit stating that he had carefully explained the grounds of detention in Gujarati to the detainee, but that is not sufficient compliance with the mandate of Article 22, Clause 5 of the Constitution, which requires that the grounds of detention must be communicated to the detainee. Communicate is a strong word. It means that sufficient knowledge of the basic facts constituting the grounds should be imparted effectively and fully to the detainee in writing in a language which he understands. The whole purpose of communicating the ground to the detainee is to enable him to make a purposeful and effective representation. If the grounds are only verbally explained to the detainee and nothing in writing is left with him in a language which he understands, then the purpose is not served and the constitutional mandate under Article 22, Clause 5 is infringed, the lordship. So, lordship, when the detainee had been supplied the relevant documents, the detention order, the approval order, and the confirmation order, he was not in a position. And when he was reduced before the advisory board, he was not in a position to exercise his constitutional right. He had no access to any legal consultation, and his constitutional right was violated, Your Lordship. So this is my second ground, Your Lordship. Further, Your Lordship,
So he was arrested where?
he was arrested on 21st of October at Chosaba town, Peg district, Your Lordship.
So he knows only 3 languages.
3 languages.
Nagamese and
Nagamese.
Hindi.
And his tribal language, Nokte.
So Nokte, I mean, anybody will be knowing Nokte here when he was arrested?
Not
Nobody
very
will
sure,
know.
Your Lordship, because he is from Arunachal Pradesh, Your Lordship.
So, and Nagamese, does Nagamese as a script to write?
No, Your Lordship.
Then how
As
it
far
will
as my
be-
knowledge.
Now how it will be done?
And Nagamis, Your Lordship, the language Nagamis.
Only they have a script.
No, Your Lordship, not scripted, Your Lordship.
So it
But
will be
Hindi, Your Lordship. But Hindi, Your Lordship. That is one of the languages.
Your ground is that, I mean, now see like the places like Nagaland plus places like Manipur,
Lordship.
There are places where English and Hindi may not be known to anybody. I mean, many people. And only local dialects are there.
Local
So
dialect.
how it will be communicated, how it will be written? Because you are saying that we're just discussing, okay,
Yes,
we're
yes.
just discussing that. And how it will be done then? In that case, written communication, how it will be done?
That I cannot answer, Your Lordship.
Are you understanding what I'm saying?
Yes, Your Lordship.
So that's a difficult situation at certain points of time.
But in this case, Your Honor,
In this case, Hindi is there.
Hindi is the, Your Lordship.
Okay.
Now, what
Yeah.
should have been done to comply with 22(5)? How in writing the grounds of arrest could have been communicated in this case?
A copy should have been supplied in a language.
In
which is
which
Hindi.
language? In which language?
Hindi, Your Lordship. Because he is familiar with Hindi as well.
Okay.
He has an education qualification only up to class 3 though. It is mentioned, it is in the record, but that should have been provided to him.
Okay.
But so far it has not been done, Your Lordship. That is one of the grounds, Your Lordship. Further, Your Lordship, the charges against him are severe in nature. There was no likelihood of him getting bail for a duration number. It wouldn't have been easy for him to obtain bail. Further, Your Lordship, in all those such periods, he had never applied for bail. Neither any of the co-accused persons had been granted bail. So the subjective satisfaction is not there, Your Lordship. Because the charges under Arms Act, Section 25, 1A, and Section 27, Clause 2, it is punishable up to life, Your Lordship. And during such period, he had not applied for bail.
How many were arrested together?
5, Your Lordship.
5 people.
5, Your Lordship. The proposal for detention was made for 5 individuals. Was passed only against 2. The detainee and Amnefo. And all the charges, Your Lordship, the charges leveled against the accused person, the detainee, are all trialable by the trial court. That is. Further, Your Lordship, the competent.
This Gujarat case is involving what? Is this preventive detention? That Lalubhai case,
Yes, Your Lordship.
it involves which act? Foreign exchange.
Foreign exchange.
Okay, for foreign exchange prevention of smuggling activities. So it is also a preventive detention.
Absolutely.
Okay.
Yes, Your Lordship.
Yes.
Your Lordship, one more ground, Your Lordship, if I may be allowed. Your Lordship, all the competent court, the competent criminal court, having found the detainee entitled to be released since on statutory bail, in the instant case, Your Lordship, had granted bail to him.
In the connected case,
Yes, in connected case,
he has been granted bail.
on statutory,
Okay.
for the Your Lordship, but he still remains under custody. still remains under custody. Still remains. He was granted bail after 119 days, after lapse of 190 days
So your
from the day
default
of
bail-
arrest. From the day of arrest.
Default bail.
Default bail, Your Lordship. And he still remains under custody, Your Lordship.
Because of this.
This detention. And the competent court, Your Lordship, has the criminal court of the law of the land is sufficient to deal with the charges, Your Lordship.
So he was granted bail in the same offense, right? When he was arrested.
Yes, Your
With the arms.
With the arms.
So he was granted bail under the Arms Act only.
Yes, Your Lordship.
That is the offense, right?
Correct, Your Lordship.
So one of your argument was that this subjective satisfaction regarding
Yes, Your Lordship.
granting of bail.
Granting of bail, but
So he's already granted bail.
granted, Your Lordship, but within that
So,
period.
no, that's what I'm asking.
Yes,
So
sir.
at one side, you are saying that the subjective satisfaction was not there
Yes, Your Lordship.
with the authorities
Yes, Your Lordship.
because that satisfaction of that he will not be granted bail or he will be granted bail
Yes,
is not there,
was not there,
was not there.
was not made.
Now what has happened is that he has been granted bail.
Yes, Your Lordship.
So
And during that period, the confirmation period, Your Lordship, the confirmation order, when the confirmation order was passed, even within that period also, he was still under judicial.
only thing is
He
that
did not move the
you
bail.
can say that satisfaction was not recorded.
Was not there
Not
while passing the
recorded in the-
detention,
Not recorded in the.
is not recorded.
Okay.
Yes.
No, please, Your Lordships. Lordships, for the sake of brevity, let me take you to my affidavit in opposition on behalf of respondent number 3. Para 7, page 5. Lordships have got it, Your Lordship.
Paragraph number
7,
7.
yes. May I read, Your Lordships?
Yes.
Yes, that with regard to the statements made in paragraph 9 to 17 of the writ petition, the answering deponent respectfully submits that being fully satisfied with the materials placed on record and after due application of mine, the detention order dated 19/11/2025, which is Annexure 7 to the writ petition, was issued, that in the grounds of detention and this schedule attached thereto, more particularly page 3 of the schedule, Your Lordships, and subclause 1 of the grounds for detention and paragraph of the schedule, it is clearly stated that if the accused person is at large, that is, if released on bail, he will be a threat to the peace and security of the state of Nagaland and the country, and there was likelihood of the accused committing breach of peace and tranquility in the state and thereby endangering the peaceful existence of the citizens. In the grounds for detention, it is stated inter alia that his activity in carrying such huge consignment of arms and ammunition directly threatens the nation's integrity and its sovereignty, which instills fear and terror in the minds of the public. It is pertinent to mention herein that the détenu, who is serving as an SS is self-styled, corporal of NSCNK.
SS means?
Self-styled, I'm not sure. Term,
Self-styled.
yes, given by. Corporal of NSCNK, Nikki faction in Dimapur ceasefire camp, Patampokri colony, as mess in charge of Arunachal Caters, was apprehended when proceeding towards Shuruhutu with a huge consignment of arms and ammunition, cash, extortion slips and notes and uniforms and other items, and during which he was arrested along with one 9mm pistol and 2 numbers of live rounds, it was established that Moase, Puane Hakun was also involved in one Consa PS case in Arunachal. Your Lordship, this covers that grounds that the petitioner had taken, that no information was recorded in the grounds of detention about his being on custody of the court.
So your ground is that you have explained it to him in Nagamese and he has acknowledged that.
Yes,
And he has issued an acknowledgement slip also. I mean, he has signed an acknowledgement slip.
yes, Your Lordships. Yes, Your Lordship.
Where is that grounds of arrest?
Your Lordship,
Where is that document?
Annexure 3,
Page 19. Page 19.
yes, page 19. Annexure 3, page 19. Lordship may also read paragraph 10, page 7. May I read the Lordships?
This.
That with regard to the amendments made in paragraph 20 of the writ petition, the answering deponent respectfully submits that white letter dated such and such, annexure 6 of the petition. Thus, Superintendent of Police PEC submitted a proposal for detention of the petitioner to the DC, District Magistrate PEC, that the answering deponent respectfully submits that the grounds of detention has been formulated in line with the established facts and circumstances of the case, and the schedule attached thereto substantiates the grounds of detention. The detainee who is serving as an SS Corporal NSCN K Nikki faction in Dimapur ceasefire camp, that's a repetition, Your Lordship. I'll just skip to the last part of the paragraph. Therefore, the questioning the legality of the detention order is baseless, since the detainee has been detained under NSA as per the merit of the case and all relevant provisions of the Act, and the laws have been complied with while passing the detention order. Therefore, the detention order was passed with full application of mind. It is respectfully submitted that the authorities had duly explained to the detainee the grounds for which he was being detained in a language that he understood, that is Nagamese, Naga Creole, and a fact of which he has acknowledged. That the approval order of the state government, which was issued on 27/11/2025, was duly reported to the central government on the same day, as per the provision of the Act, and by email and speed post. I've annexed those annexures in Lordship. And also, that also White Letter 5/12/2025, which is within the stipulated period of 3 weeks, provided under the NSA Act, the government referred the detention order dated 19/11/2025, along with all relevant documents, to the NSA Advisory Board. The answering deponent respectfully submits that being fully satisfied with the materials placed on records and after due application of mind, the detention order dated 19/11/2025 was issued, that there has been no violation of law or procedural lapses as provided under the Act. Therefore, there is no infirmity in passing the detention order directing to detain the detainee under the preventive detention law and the subsequent extension orders for the further detention of the detainee. The Lordship, the records will reveal that there has been no procedural lapses. We have followed all the timeline given by the Act, in Lordships. In regards to subjective satisfactions, Your Lordship, the accused being a caterer from another state and harboring in Nagaland, working from Nagaland, Lordship, those were and the fact that he was caught with a huge consignment of arms and ammunition, those were the aspects that the detaining authority had to look into. And they could not take a chance for releasing on bail because there's likelihood that he would go back to his mother state. That's the submission of the state, Your Lordship.
What about the language? I mean, he has placed a case of the Supreme Court,
Yes.
wherein Supreme Court has specifically stated that grounds has to be given by way of a written communication
Yes, Your
in a
Lordship.
language which is known to him.
Yes.
And on record,
Hmm.
3 languages are known to him.
Yes.
So that the grounds of arrest were not given any of those languages. So how will you meet that?
Yes.
That
Yes, Your
complaint?
Lordship. No written, does not communicated to him in writing, Your Lordship. Yes, the courts does not have that. It was only explained to him in Lagamese.
So do you have any judicial pronouncement which says that if it is given written in a different language, but the same has been duly explained to him, then there is a compliance?
No, Lordship, I could not come up with that. Giving that exception, I could not come any.
What is your name?
M. Longcomer, Your Lordship,
Oh, I am Lunko. You are public prosecutor.
the government advocate.
Heard. Mr. Varun Bardeva, the learned counsel for the petitioner. Also heard Mr. M. Longkumar,
Lordship.
learned government counsel. And N. Anguli. You have any? Z,
Yes, my lord, I submitted my petition for this.
Z. Anguli. Your submission is similar to that of
Yes, yes, yes.
Z. Anguli, learned Central Government Council, appearing for respondent number 4. This writ petition under Article 226 of the Constitution of India has been filed by the petitioner Miss Litfe Sumnayan, who is the wife of the detainee, Mr. Moase alias Pune Hakun, impugning the detention order number DCP/CON-66/88-89/189 dated 19 November 2025, passed by the Deputy Commissioner and District Magistrate Fake, Nagaland, whereby the detainee, that is the husband of the present petitioner, was ordered to be detained in Central Jail, Chumukidima, Nagaland, under Section 3 within bracket 1 and Section 3 within bracket 3 of the National Security Act 1980. The petitioner has also impugned the approval order of the detention passed by the Special Secretary to the Government of Nagaland on 27th November 2025, as well as confirmation order passed on 17th February 2026 by the Special Secretary to the Government of Nagaland. The petitioner has also impugned the extension order number CON/NSA/17/2025/1990/90 dated 15/6/2026, whereby the detention of the detainee was extended with effect from 19/5/2026 till 18/8/2026. The facts relevant for next para. The facts relevant for consideration of the instant writ petition, in brief, are that on the basis of a complaint received from the commandant, from the COB commander of 13th Assam Rifles regarding trafficking of huge quantity of arms and ammunition from Dimapur towards Shuruhoto Camp Zuneboto. The how many were apprehended total? 4 or 5?
4 in the vehicle, along with 1, 5 total.
Total 5 accused persons were apprehended, including the husband of the present petitioner, on 21/10/2025. The husband of the present petitioner, along with other 4 co-accused, were found as occupant of Maruti Gypsy vehicle bearing registration number NL07CA 4302, from where huge cache of arms and ammunition, cash extortion slips, uniforms and other items were recovered. Stop. Next para. In connection with the aforesaid incident, Chozoba PS case number 004/2025 under section 308 within bracket 2 /3 within bracket 5 of BNS, read with section 25 within bracket capital 1 capital A bracket close /27 within bracket 2 of the Arms Act, read with section 7 and 8 of Nagaland Security Regulation was registered. after 5 days of detention of the above of the accused persons in judicial custody. No, in judicial custody, the superintendent of police fake signed letter dated 4/11/2025 proposing for detention of the husband of the petitioner under the provision of National Security Act. Stop. Thereafter, the district magistrate fake who passed the detention order?
District Magistrate, Your Lordship.
District magistrate fake by detention order number capital DCP /CON -66 /88 -89 /189 dated 19 November 2025 passed the detention order under section 3 within bracket 1 and 3 within bracket 2 of the National Security Act 1980 against the husband of the petitioner and one another accused person of the aforementioned case, namely Ameni Phone. The said, next para, the said detention order was approved by the Chief Secretary to the Government of Nagaland on 19 November 2025. When the approval was granted? 27 November 2025. Initially for a period of 3 months till 18 to 2026. Stop, next para. Thereafter, based on the opinion of the advisory board dated 15/12/2025, the husband of the present petitioner was detained for another period of 3 months with effect from 19/2/2026 to 18/5/2026. Stop, next para. In the meanwhile, the detainee made a representation dated 9/3/2026 to the Special Secretary Home, Government of Nagaland, seeking revocation of the detention order. However, Same was rejected. And was communicated through wireless message dated 17/3/2026 by the central government to the Chief Secretary Nagaland. Stop next para. Thereafter, the respondent number 1 by order dated 5/15/5/2026 further extended the detention of the detainee for another 3 months with effect from 19/5/2026 till 18/8/2026 under section 12 within bracket 1 of the National Security Act 1980. Stop. Mr. Next para. Mr. Varun Bardeva, the learned counsel for the petitioner, has submitted that the detention order passed by the respondent number 3 is illegal in as much as though at the time when the detention order was passed, the husband of the petitioner was in judicial custody in connection with Chozoba PS case number 004/2025. The said fact was not reflected in the detention order. Stop. Neither anything has been mentioned in the detention order that there is a apprehension that the detainee is likely to be released on bail. And further, if so released, there is every possibility of him being again indulging in disruptive activities, which would be detrimental to public order, peace, and tranquility of the state. He submits that omission to mention the subjectives, omission to mention the aforesaid facts vitiates the subjective satisfaction of the authority passing detention order under the provisions of National Security Act. He submits that in this regard, the apex court in the case of Widrom Onunjao Singh versus State of Manipur and others reported in, what is the citation?
2012, volume 7.
2012 7 SCC
Which one?
181 has observed as follows. No, no. What was the last line? No, no, stop, cut this. In support of his submission, he has cited the ruling of the apex court in the case of Widrom Kanunjo Singh and state versus State of Manipur and others reported in so and so. Stop. The next para, the learned counsel for the petitioner submits that though it is an admitted fact though it is an admitted fact that the husband of the petitioner, that is the detenu, Moase Haukum, belongs to Nokti tribe of Arunachal Pradesh and understands only 3 languages, namely Nagamese, Nokti and Hindi, as apparent from the arrest memo prepared at the time of his arrest in connection with Chosuba PS case number 004/2025, however, the detention order, the approval order, and all the relevant documents by which he was communicated the grounds of arrest were in English language. And as such, he submits that were in English language, which he does not understand. Stop. And the learned counsel for the petitioner submits that by not communicating the grounds of arrest in the language, grounds of arrest, in writing, in the language understood by the detenu, the respondent authorities have violated the constitutional mandate as provided under Article 22 within bracket 5 of the Constitution of India. And as such, he submits that the detention order, its approval and subsequent extension orders are liable to be quashed. In support of his submission, he has cited a ruling of the apex court in the case of Lalu Bhai Jogi Bhai Patel versus Union of India, reported in (1981) 2 SCC 427.
Is 81 or 80?
It is
80 listen. Is 80.
into, yeah. What is this?
81.
81, no? 81
1980.
2 SCC 427.
Yes.
427. Stop. The learned counsel for the petitioner submits that though in Chozuba PS case number 004/2025, the husband of the petitioner has already been granted default bail after lapse of after 119 days of detention in that case. However, he has been still behind the bars for the detention order passed against him by the respondent authorities under the provision of Nagaland National Security Act in 1980. Stop. On the other hand, Mr. M. Longkumar, the learned government counsel representing the state respondents, has submitted that the husband of the present petitioner was found involved in trafficking huge gauge of arms and ammunitions, which was detrimental to the interest of state, and as such, after following the procedural requirement as provided under National Security Act, his preventive detention order was passed under Section 3 of the said Act. He submits that the grounds of, where are the grounds of detention?
Page 72 of the writ petition, Your Lordship. Clause I.
What was the last line? Grounds of detention mentioned in the order dated 19/11/2025 clearly specifies that if enlarged on bail, the detainee will be a threat to peace and security of the state of Nagaland. State of Nagaland. Whether the fact that he was in judicial custody
Lordship,
is also reflected in this detention order.
not specifically, that word is not reflected, Your Lordship. But you
Okay,
can just,
stop,
yes.
stop.
And even you can, if Your Lordship can see page, the next page, the schedule. Para 4.
Stop. He further submits that though the grounds of arrest, grounds of detention of the detainee have been mentioned in English language. However, it has been explained to the detainee in Nagamese. That is the language which the detainee understands. And to that effect, an acknowledgement has also been obtained from the detainee. Where is the acknowledgement?
Page 19 of my affidavit in opposition for respondent 3. Page 19.
Wherein he has acknowledged that contents of detention order dated 19/11/2025 have been explained to him in Nagamese language. As such, he submits that there has been no violation of the constitutional mandate under Article 22 within bracket 5 of the Constitution of India, justifying any interference by this court with the order of detention as well as approval thereof and subsequent order of extension of detention under the provision of National Security Act 1980. Stop. Mr. N. Anguli, the Learned Central Government Council, has adopted the submissions made by
Apart that, Your Lordship, the representative of the TNU has, we have a promptly headed upon the representative of the TNU. As far as possible, we have disposed that representative of the TNU within 7 days. That what is my question.
Learned Council for the state respondents. Further, he has submitted that the representation submitted by the detainee against the detention order has been expeditiously disposed of by the central government within the statutory period prescribed under National Security Act 1980, and as such, there has been no violation of any statutory provisions or constitutional provision justifying interference by this court with the detention of the detainee, that is the husband of the present petitioner. We have, next para, we have considered the submissions made by Learned Council for both sides and have gone through the materials on record, including the writ petition and the affidavit in opposition filed by the state respondents. Stop. We have also gone through the rulings cited by Learned Council for both sides in support of their respective submission. While next para. while considering the question as to whether the subjective satisfaction based on materials available on record of the authority passing detention order under Section 3 of the National Security Act 1890 should be interfered with or not, comma, the Supreme Court of India in the case of withdrawn Konunjao Singh versus State of Manipur and others within bracket Supra has observed as follows. Quote paragraph number 9 from the aforesaid judgment. Next paragraph. In the instant case, if we peruse the detention order, there is no mention therein that the fact that the petitioner, husband of the petitioner, he has already been detained in judicial custody in connection with in connection with which police station?
Chozuba.
Chozuba. Chozu Ba PS case number 004/2022 has been mentioned therein. There is also no mention about the basis on which the authority passing the detention order has come to a conclusion that there was real possibility of releasing the detainee on bail, and that on such release he would probably indulge in the activities which are prejudicial to public order. Stop. Further, next para. It also appears that the arresting authorities were aware of the fact that the petitioner belongs to Nokti tribe of Arunachal Pradesh and understands only 3 languages, namely Nokti, Nagamese and Hindi. Under such circumstances, the question before us is as to whether there was a necessity of communicating the grounds of arrest to him at the time of his arrest in writing in a language which he understands? Or is it sufficient compliance if the arresting authority state that the grounds of arrest were made known to him in a language understood by him, and thereafter obtaining an acknowledgement thereto from the detainee? Stop. In this regard, the observation of the apex court in the case of Lalu Bhai Jogi Bhai Patel versus Union of India and others within bracket supra are relevant and same are quoted herein below. Quote, I have marked it as A. You have to quote it from there, from the judgment. Quote A from in view of the above observation by the apex court, it appears that it is not a sufficient compliance of the mandate of Article 22 within bracket 5 of the Constitution. If the detaining authority explain the grounds of arrest orally in the language which is understood by the detainee, what is required is to communicate the grounds of arrest, in writing, in a language which he understands. As such, the requirement of communicating the grounds of arrest in writing in either Nagamese, which tribe? Nokti, Nokti, or Hindi was necessary for complying with the mandate of Article 22 within bracket 5. In view of above discussion, the detaining authority, the order of detention which has been impugned in this writ petition suffers from infirmity and suffers from incurable infirmity, and as such same gets vitiated. Stop it. In view of above discussion, the impugned detention order, its approval and subsequent extension orders passed by the respondent authorities are hereby set aside, and this writ petition is allowed. The husband of the detainee, husband of the writ petitioner, namely Mr. What is his name?
Moase,
Moase,
alias Pune Hakun.
be immediately released from detention if not required in connection with any other case. This writ petition is accordingly disposed of.
So bless your lordship.
Bless your lordship.
For admission, item number 20.
May I plead
Yes.
Lordships, I'm appearing on behalf of the petitioner in the instant matter. Your Lordship, since in the instant writ petition, I'm challenging my detention order. So it's futile to go into the merits of the case. No doubt the detaining authority has got power to exercise my detention under the relevant law, that is NSA. So here, basically, Your Lordship, I am challenging my detention on the basis of technicalities. So Your Lordship, before instead of going into the merits of the case, I may be allowed to challenge my detention order on the grounds on which I am relying. Your Lordship, my first ground is that while I was already under custody, my detention order was passed. Now, in my detention order, the detaining authority has not mentioned that I was already under judicial custody in connection of so-and-so case. So in that regard, Your Lordship, I'm relying on the judgment of this honorable court only. That is Longlem Form versus State of Nagaland and others, which was reported in 2017 to GLT 506. The relevant portion of this judgment is, Your Lordship, I may be allowed to read, that is paragraph 9, Your Lordship.
Just be slow.
Paragraph 9.
Let us get the judgment.
Okay.
Para?
Para 9, Your Lordship. Actually, I am relying on para 6 and 9, but more particularly, it is relevant with para 9.
Yes.
Yes, I may be allowed to read this particular paragraph, Your Lordship.
Yes.
Para 9, from the principle of law enunciated by the Honorable Supreme Court, which still holds the field till today.
No,
It is clear.
Which para you are reading?
Which para you are reading?
Para 9, Lordship, para 9.
Para 9, which case?
In the case of Longlem Form versus State of Nagaland and others.
Yes, provided a
Different copy has been served to us.
Longlem.
This case
Yes.
is something.
Kiba.
Yes, Kiba.
Hey, Kiba.
Ekui Kiba.
No, that is also after this citation only. I will come to that case, Your Lordship. But anyway, if
the copy which has been given to us is different, the paragraph you are reading is different, and how we are going to follow this?
Lordship, I am relying on two judgments. Both judgments are of this honorable court.
Good. So you have given the copy, then you read that judgment. That Kiba judgment.
Okay, Lordship, regarding that judgment, Your Lordship, then I am reading, that is para 32, Your Lordship.
Para
32.
32.
And this judgment was passed in this year only on 20 May 2026. Para 32, Your Lordship.
Yes.
Yes. In Longkumar Form Supra, this court has held as follows. From the principle of law enunciated by the Honorable Supreme Court, which still holds the field till today, it is very clear that while considering the detention of a person who is already in custody in connection with other cases or case, the district magistrate who is passing the detention order must first acknowledge and reflect the same in his order that the fact that the person intended to be detained under NSA is under custody and there are reasonable and cogent reasons to believe that he is likely to be released on bail, and if he is released, he is likely to disturb public order, peace and tranquility of the state because of illegal activities in the approximate past. In this case, as Your Lordship, here this particular paragraph, it clearly says that in the detention order itself, the detaining authority has to acknowledge and reflect the fact that I am already under judicial custody in connection with any other case. But in my detention order, that has not been reflected. Note, Your Lordship, I am acknowledging the fact that in schedule or so to say annexure, along with my detention order, this fact has been reflected. But this particular judgment is very clear in the fact that it has to be reflected in the impugned detention order itself and not as annexure or schedule. So basing on this judgment only, this particular petition was also allowed by this particular court, because in my detention order, there is no reference regarding that I was already under judicial custody in connection with so and so case. So that has not been reflected in my detention order. Now, secondly, your lordship, since I have been detained under NSA Act, so as per NSA Act, under under section 3(5), your lordship, of the NSA Act,
Section?
it says that the detaining authority, while exercising power under
Which
this
provision? Which provision?
Section,
section 3(5) of the National Security Act, lordship.
section, which section?
Section 3(5) of the National Security Act.
Yes.
It says that, your lordship, while the state government passes any detention order or approved by the state government, the same has to be reported to the central government within a period of 7 days from the date of passing of the detention order. But here in this case, there is no record which shows that the state government, after confirming my detention order, has reported to the central government within 7 days. And the state respondent, in their affidavit, they have nowhere stated that they have complied with this provision. So no doubt, your lordship, the detaining authority has power to detain under this act, NSA Act, but at the same time, there are procedure. The procedure, or so to say, the mandatory procedures has to be complied with before exercising that power. So in state's affidavit, they have nowhere stated they have complied with this provision. Then, your lordship, again, section 10 of the National Security Act says that after the detention order, within 3 weeks, the state government has to place the record along with the grounds of arrest before the advisory board. Here, no doubt, your lordship, in my confirmation order, they have stated the matter was reported to the advisory board, but they have not stated the date. They have only stated that on 13/1/2026, they have this advisory board has reported that there was no merit in my representation, and the advisory board has rejected my representation. But whereas there is no proof on which date the state government has referred the matter before the advisory board. Your lordship, I am relying on many of the grounds, but basically on these 3 grounds. Number 1, your lordship, as I said, in my detention order, the detaining authority has not reflected that I was already under judicial custody. Number 2, your lordship, section 3(5), which says that from the date of my detention or the approval, the state government has to refer the matter to the central government. That has also not been complied. And within 3 weeks from the date of detention, the matter has to be placed before the advisory board under section 10. That has also not been done. No doubt, in my confirmation order, that has been referred. But I don't know whether the record of the case has been placed before the honorable court or not. But since I have not got those documents, so the honorable court may scrutinize that whether within the period of 3 months, the state government has placed my record before the advisory board or not.
Yes.
May I please, your lordships? Your lordships, I'll just begin by clarifying 2 things, your lordship. With regards to the petitioner's averment that the detention order was not referred to the Union of India or the advisory board on time. Your lordship, those 2 are not the grounds that they have taken. As such, I have not specifically written to that, objected to that, those 2 grounds. They have not taken that ground in their writ petition, your lordship.
Okay,
But
they
I-
have not taken that
that-
ground in their
with petition.
writ
Yes.
petition.
Hence I did
The
not.
violation
yes.
of section 3, clause 5,
Yes,
and
and
section
section
10.
8. Yes,
Therefore, you
Yes,
could
ma'am.
not respond to it.
yes, your lordship. But records would show that everything is on time, your lordship. Records would reveal that. And with regards to his first ground, that no, there was no mention that the
You can bring that on record. The filing additional affidavit.
your lordship. Your lordship.
We give a short date. Let him file an additional affidavit.
Your lordship, in that case, 1 week's time may be given only, your lordship, since it's a habeas corpus petition.
Yes.
Because I fairly admit the fact that in my grounds, I have not mentioned this section 3.5 and section 10 of the NSA. I admit that fact, but having said that, this honorable court cannot bypass that mandatory provision of the NSA Act.
How
Because
will we
ultimately,
know, apart from your mere oral submission, without any affidavit? Where the
lordship, that is what your lordship, even if I have not pleaded that in my petition, this honorable court can also take cognizance of the fact that because ultimately I have been detained under NSA Act only. So this honorable court has to see whether the provisions, while exercising the powers under NSA, whether the detaining authority has complied with the mandatory.
Let them file. Let them file. Heard Mr. P. Soren, the learned counsel for the petitioner. Also heard Mr. M. Long Kumar, learned additional public prosecutor. While making submissions, the learned counsel for the petitioner referred to violation of the provisions contained in section 3 within bracket 5 as well as section 10 of the National Security Act by the detaining authorities. Stop on this. Learned Government Counsel Mr. M. Long Kumar submits that these grounds are not specifically pleaded by the petitioner in his writ petition, and as such he seeks some time for filing an additional affidavit to bring on record the facts which would nullify the submissions made by learned counsel for the petitioner. The prayer is allowed. The state is allowed to file additional affidavit on or before the next date fixed. Let this matter be listed again on 12th of August.
Your lordship, just a point of clarification. Will this additional affidavit be filed by can it be filed by the state government, your lordship,
Yes.
not the detaining authority? Because if it's the detaining authority, I have to send it again to.
By the state government,
Your lordship.
list accordingly.
Oblige, your lordship.
For admission, item number 21.
Lordship, this is analogous case because in the same case, these two detainees were arrested. So similar order may be passed, your lordship.
Same order in 21 months.
Oblige, your lordship.
Obliged, lordship.
For authors, item number 28.
28. Yes.
Last occasion on 3/6/2026, an order was passed directing the Juvenile Justice Board, WOCA, to take a decision as to whether the son of the petitioner was a juvenile as on the commission of the date or commission of offense on 16/12/2024 and submit a report before this court. I don't know whether the report has gone. And also the counsel of the petitioner. didn't
Report
is-
has come in a sealed envelope. Where is? I see.
Yes, my lord. I'm sorry, my lord. I'm there, my lord.
Gauhati, Germany. Gauhati, District Administration. Yes. Yes, Mr. Murray, what was your case? What is your case? He has been found to be juvenile on the date of alleged offense.
Lordship. Lordship, if that is the case, petitioner may have, to assist the court, petitioner may have a case in her favor.
And we can put it for hearing purpose.
Oh, yes, Lordship.
Yes, Mr. Murray, you have any submission?
My lord, my lord, I was not audible, my lord, what lordship was indicating, my lord.
The who is the petitioner here?
My lord, here the petitioner is the mother of the detainee, my lord.
The detainee is found to be juvenile on the date of alleged offense.
Absolutely, lordship. Lordship is right.
Why you approach this court? Okay. Justice Board should consider the application for the treated as a juvenile. Anytime the petition is project for juvenile justice board consider for the under detention of the minor then removed by observation. I can read you any method to fully decide another submission. Yes, Mr. Angami. No, before that, Mr. Murray, what is your submission now?
My lord, here, my lord, if in the events, my lord, if in terms of the last court order on this honorable court order, if the report is affirmative, my lord, then petition may be allowed.
Where is the last photo?
Where does it say so? Where does it say so?
My lord, if the learned JJB, my lord, if the report is submitted affirmative in my favor, then my lord, this writ petition may be allowed, my lord.
And what is your prayer interpretation?
My writ petition is, my lord, saying that, my lord, on the ground that since I was a juvenile on the date of commission of offense, therefore, my lord, the moment I raise a plea of juvenility, I should not be detained in judicial custody, in jail or remand.
Yes.
Or in police lockup.
He should be put where?
I should be put in some observation home like my lord, as per the act.
What does the act say?
The juvenile act says, my lord, accused that person in conflict with law cannot be at no point of time can be put in lockup or in jail, my lord. It must be in observation home. Deal they met.
He shows the provision.
Yes, my lord. Lordship may kindly before that kindly see the last order, my lord.
Yes.
Last order, my lord. Last order passed by this court, my lord.
Yes. Yes, which portion you want to refer to?
Now kindly see section 10, my lord, of the act.
No, I mean, see, there was a direction for the age verification, right? By the juvenile.
Yes, my lord. Yes, my lord.
Has been carried out. Correct.
Yes, my lord.
It has come to our notice that he has been declared as a juvenile in terms
Lordship.
of juvenile justice.
Yes, my lord.
After
Now,
the-
lordship, then
verification.
No, what was the order dated 7/3/2025?
7-3 was the order passed by lord. Without hearing the, my lord,
What was the
accused
order?
that ossification order has been passed. Ossification test was ordered to be conducted.
Lordship, if I may.
That has already been,
Yes,
that has already
yes,
been kept
yes.
in abeyance.
Yes. Lordship is correct. Kindly see section 10, my lord.
No, just wait for. Yes, Mr. Angami.
Yeah, Lordship, in the end, maybe in favor of, likely may turn out to be in favor of the petitioners. But in the interest of justice, since the order has just come, if I may be allowed to peruse the report also and take
Yeah.
up the matter on another day convenience to this court. So give us some time to go through the report as well as and dispose thereafter. If that can be done after some other date. If that.
Now, where is the detaining detained? Where he
He's on bail. He's on bail. He's on default bail. He's not.
He's on bail.
Yes.
Yes.
Yes, he's on
But
bail.
in pursuance to this honorable court interference, my lord, I am already now released, my lord.
Yes.
Okay. Then what relief you are seeking in this writ petition?
My lord, I should be, since my lord, due to other prayer, my lord, has already existed, my lord. Relief has been granted. Now only thing, my lord, since once I am my lord declare as juvenile, my lord, then if this court accepted the report, my lord, then my detention may be, my lord, may be declared as, my lord, illegal, my lord.
No, how? Without, only after ascertaining your age. Till your age is ascertained.
Yes.
Your main prayer was
Release.
release on bail.
That has already been done.
Which has already been done.
Yes.
Still, we'll fix it on next, on 12th. Furnish Koridam copy registration furnish. Heard Mr. N.K. Mure, learned counsel for the petitioner. Also heard Mr. K.V. Angami, the learned public prosecutor. In pursuant to the direction passed by this court in its order dated, by its order dated 3/6/2026, the Juvenile Justice Board, VOCA, has furnished the report regarding the age of the son of the petitioner at the time of alleged offense. We have gone through the said report. It has been stated in the said report that the Juvenile Justice Board came to the conclusion that the son of the petitioner was below the age of 18 years on the date of alleged offense. Stop. The son of the petitioner has already been released on bail by this court's earlier order. Stop. Mr. K.V. Angami, learned public prosecutor, submits that in order to assist this court in a better way, they may be allowed to access the report submitted by Juvenile Justice Board VOCA before he makes a submission in this case. So the prayer is allowed. The registry shall furnish a copy of the report. Furnish a copy of the order dated 12/6/2026 and 24/6/2026 passed by the Juvenile Justice Board, VOCA, whereby it has ascertained the age of son of the petitioner and found him to be juvenile on the date of the alleged offense, comma. क्या ये लाइन क्या लिखा? Two, comma, last line, last word, comma, to the learned counsel for the petitioner as well as learned public prosecutor within 2 days from the date of this order. Let this matter be listed again on 12th of August.
I'm obliged, my lord.
For hearing, item number 36.
Lordship, may I pray the matter may pass over a time being, your lordship. My senior is on legs, lordship. After some time, your lordship. We'll do the matter today, your lordship, after some time.
Your lordship, last time also after some.
Lordship, after some time, lordship, we'll do the matter today. We'll do the matter.
Reasons
After
is
some time.
They said. they
Lordship,
saw-
we'll do the matter. We'll do the matter.
Let it start now. Let it start. I'm objecting to that.
Lordship, after 10 minutes, your lordship, I'll call my senior, your lordship.
No.
After 10 minutes. your
Dude, if they cannot take up, then they should have mentioned early in the morning. Not in
Lordship, we're doing the matter today, your lordship.
We are
We are
playing
praying
the
for
court.
after some time, your lordship. Pass over, your lordship. We're
Not
doing the
playing with
matter.
court. We're serious. We are not playing with the court.
Lordship, we'll do the matter today, your lordship.
No, this is the second time, even the third time.
Lordship, we'll do the matter today.
Your lordship, let them start. They
I'm
are-
just praying for a pass over, your lordship, for time being. In 10 minutes, we'll start the matter.
No. I'm objecting to that. Let them start now.
The council is not, who will be arguing?
Mr. Chaudhary will be appearing, your lordship. 10 minutes, your lordship.
Let them Council Chaudhary will argue.
I'll call my senior.
Not
If
there.
he is not available, then why don't they mention early in the morning?
Yes.
Lordship, we'll do the matter today.
For the whole day.
We are doing the matter today, your lordship.
Hey, we're not playing. We are not playing with our clients. or
Yes.
with the courts.
What is your name?
I'm N. Gautam, your lordship.
Mr. Gautam.
Lordship.
You should have known that this item is going to be taken up as the first item after
Lordship,
lunch.
understood one matter continued before lunch, your lordship. That is why I'll call my senior. In 10 minutes, we'll start, your lordship. 10 minutes.
Occasion, we have sought, we have this.
In 10 minutes, we'll start.
No more adjournment, lordship, because.
No, in 10 minutes, we'll start.
They are not seeking adjournment. They are only praying for
We are
waiting
trying to
for.
postpone the matter. Same with the last time. They did
Lordship,
exactly.
we'll do the matter today, your lordship. I do not understand why this is happening. We'll do the matter today.
In the first hour, they said, wait for some time. Then it was called in the second half. Then they sought for adjournment again. Same with today. No, let them start now, your lordship.
Lordship, in 10 minutes, if it does not happen, I'll start, your lordship. I'll start my argument, your lordship.
Start now.
I'm just praying for 10 minutes.
Whether good or bad.
I'm praying for 10 minutes, your lordship. Otherwise, I'll start. I'll start the argument. There's
We
no
not
difficulty.
your lordship. Let them start, your lordship.
No, we need good assistance.
Lordship, 10 minutes, your lordship.
So we do say that.
10 minutes, we'll start.
We'll take it up after some time.
Lordship.
After some time.
Lordship.
For hearing, item number 38.
Yes, lordship.
38.
May it please, my lord. Lordship, this is a third party appeal, my lord. This is against judgment and order dated 5/5/25. Lordship, the matter in this, issue in this case is regard to a post of medicine carrier, my lordship, a vacant post of medicine carrier. Now, the learned single judge has directed that the post, as this post was directed to be given to the writ petitioner, lordship, without any selection process, your lordship. So our case is that in terms of constitutional scheme, your lordship, a vacant post has to be only be filled up by way of open selection process, where aspirants like me and others who wish to apply may be able to participate, my lord. So, lordship, if I may be allowed to take this lordship to the facts leading up to this case, your lordship.
Yes.
So, lordship, in 2010, lordship, a vacant post of medicine carer arose, lordship, in the veterinary health center, Sitimi Kefri, my lord. Now, the writ petitioner The writ petitioner submitted an application, and by order dated 6/10/2010, his application for appointment was approved, my lord. 6/10/2010. This date is important, my lord. His application for appointment was approved. This is an approval order, your lordship. So this approval order was challenged by the private respondent by filing WPC.
Where is the approval order?
Lordship, approval order is page 40, my lord. Page 40. This is a type copy, lordship. 39 is the approval order. It's not very legible, so type copy is at 40, my lord. Serial number 13 is the writ petitioner, my lord. Page 40, 13. Now, your lordship, the
One second, one second.
Yes.
Yes.
So after this, your lordship, the private respondent, he challenged this approval order, your lordship, by filing WPC 166 of 2010.
And this approval at page 40.
Yes, your lordship. This was challenged by the private respondent in WPC 166 of 2010, your lordship.
Now, how this was appointed? These people were appointed on what basis?
They just, they
These 30
submit,
people were appointed on what basis?
by submitting the application. Lordship,
Can it be
it
done
showed
like that?
backdoor, yes, yes, lordship.
Can it be done like that?
No, lordship. It cannot be.
Okay.
Yes, your lordship.
Then-
Thereafter, your lordship.
So it was challenged by the
private respondent.
respondent.
Yes, your
Okay.
lordship. Lordship, here this is a third party appeal, your lordship. I'm not a writ petitioner, lordship. This is a third party appeal.
How do you agree?
Lordship, my case is that when there's a vacant post, it should be advertised, your lordship, for all eligible candidates to participate, your lordship.
Are you eligible?
Yes, your lordship, I'm eligible, lordship.
Let us see the order. Let us see the impugn order.
Your lordship.
That order that you are trying
Yes,
to
ma'am.
challenge.
Is it the first page, my lord? First page, my lord.
Page?
First page.
Huh?
First page, and it's
Page, yes.
Operative portion is at page. Paragraph 9 onwards, my lord. Paragraph 9 onwards.
9 onwards.
Order dated?
5/5/25. Lordship, this case has a checkered history, my lord. Multiple writ petitions were filed, your lordship.
No, read the impugn order, complete impugn order.
Lordship,
Read the impugn judgment.
paragraph 9, my lord.
No, not paragraph 9. Even
Start from the beginning.
from the from
Paragraph 2.
2.
The writ petition under Article 226 of the Constitution has been filed by the petitioner on the following facts. It is stated that the petitioner was appointed as medicine carrier by order dated 14/2/12. Thereafter, the approval of the petitioner as medicine carrier as well as the appointment order was challenged by the present respondent number 4 by filing WPC 166K of 2010 on the ground that he is the landowner of the land on which the present District Veterinary Service Kifre is situated, and claiming appointment on land ownership basis on the strength of an agreement dated 14/2/1972 and affidavit dated 7/2/2009. After hearing the parties, this court, by order dated 24/6/2011, disposed of WPC 166K of 2010 with a direction to consider the matter afresh. Taking into consideration all the parties, the respondent number 4 and the petitioner will also be given personal hearing before finalization of the matter by passing appropriate speaking order. Thereafter, both the case of the petitioner and the respondent number 4 were considered, and the affidavit dated 7/2/2001, basing on which the respondent number 4 claimed appointment was found to be unauthorized and against the standing government notification issued by notification dated 26/7/2005. Accordingly, by order dated 15/9/2011, the respondent authorities reaffirmed the earlier approval order issued in favor of the present petitioner, and by the said order dated 15/9/2011, the affidavit dated was nullified by the government as unauthorized. Thereafter, against the order dated 15/9/2011, the present respondent number 4 filed a writ petition being WPC 238K of 2011. During the pendency of the said petition, the present petitioner was appointed as medicine carrier on the strength of an approval order dated 6/10/2010. The respondent number
One second, was all these appointments were on the basis of this notification, government notification 26/7/2005? Is it the case regarding, I mean, if somebody gives a land and somebody, I mean, then, and there is some
Yes.
agreement to the government department?
Yeah.
Because I'm not very aware of this, I'm asking, is there a notification like that?
Yes, there's a
That
notification.
if you give some land of your personal land.
Yes, there is a notification.
Then there will be some appointment.
Yes,
So on the basis of this appointment notification, these people were appointed, approved.
No.
No.
The writ petitioner, his appointment was on the basis of an application given by him.
Hmm.
No.
But he was, I mean, not for this.
No.
Notification.
It was private respondent's claim. When the private respondent approached this court challenging his approval order,
Okay,
his claim was.
Okay, go ahead.
Yes, Your Lordship.
Then we'll.
Thereafter, yes, thereafter against the order dated 15/9/11, the respondent number 4, being aggrieved by the appointment of the petitioner, filed another writ petition being WPC 13/1K of 2012, challenging the appointment order of the present petitioner dated 14/2012. Since the issue involved in the aforesaid 2 writ petition were based on similar facts and circumstances, this court heard the matter together and by common judgment and order dated 29/2013, set aside the approval order of the petitioner dated 16/10/2010, as well as the appointment order dated 14/2012. Subsequently, the respondent number 4 herein was appointed to the post of medicine carrier under the establishment of the District Veterinary Office, Kifri. Paragraph 4, the petitioner herein being aggrieved by the judgment and order dated 29/2013, filed WA 18K of 2013 and WA 19K of 2013. The appellate court, by judgment and order dated, allowed the writ appeals, holding that the document dated 7/2009 has no legal validity in the eye of the law, and therefore set aside and quashed the appointment order of the respondent number 4 dated 28/11/2013. It is the contention of the learned counsel for the petitioner that direction passed by the appellate court in judgment and order dated 26/6/2018 is clear and without any ambiguity. However, it is stated that the respondent authorities are still allowing the respondent number 4 to continue in service in spite of that fact. In spite of that fact that his appointment has already been set aside and quashed. Therefore, the petitioner is now before this court praying for 1, complying with the judgment and order dated passed in WA 18K of 2013 and WA 19K of 2013. 2, a direction to the respondent authorities to restore the approval order dated 6/10/2010 and the appointment order dated 14/2 in favor of the petitioner. 3, a direction to the respondent authorities to terminate the respondent number 4 from service and appoint the petitioner against the post held by the respondent number 4. 7, learned senior such and such has submitted on the basis of his additional affidavit herein, wherein at paragraph 3 and 5, it is stated that the appointment of the respondent number 4 as medicine carrier under the establishment of the Animal Husbandry Center at Stimi has been removed by an order of cancellation dated 14/4/2025, which has been annexed in the additional affidavit as Annexure B. It is therefore submitted that the direction of the appellate court has already been complied by the government respondents by order dated 14/4/2005, by which the appointment of the respondent number 4 has been cancelled with immediate effect. Learned counsel such and such appearing for the respondent number 4 has submitted that even though the WA 18K of 2013 and WA 19K has been allowed by the appellate court, however, there is no clear direction that a petitioner should be appointed in the said post which was held by the respondent number 4. She has also submitted that the present petitioner has never submitted any application praying for his appointment till today. The learned counsel also states that the petitioner was appointed on 14/2/2012 for a period of 1 year with the condition to be terminated with 1 month's notice. As by this time, 1 year period has already expired, and on this ground alone, the writ petition is liable to be dismissed. 9. This court has considered the submissions of the opposing parties and perused the judgment of the appellate court in WA 18K of 2013 and WA 19K of 2013. It is seen that at paragraph 17 of the said judgment and order, the appellate court has specifically stated that the order dated 28/11/2013, by which respondent number 1 therein was appointed as medicine carrier and veterinary and animal husbandry center under the establishment of veterinary and animal husbandry office, KEFRI, is set aside and quashed. WA 18K of 2013 and WA 19K of 2013 has been filed by the present petitioner against the judgment and order passed in WPC 31K of 2012 and WPC 238K of 2011, by which his appointment and approval were quashed and set aside. Therefore, it is the view of this court that when the writ WA 18K of 2013 and WA 19K of 2013 were allowed by the judgment and order dated 26/6/2018, thereby quashing the appointment of the respondent number 1, it would mean that the approval order and the appointment order of the petitioner stands revived. Accordingly, the writ petition is allowed. The respondents have already complied with the prayer of the petitioner for terminating the respondent number 4 from service by order dated 14/4/2025. Accordingly, the respondent number 1, 2, and 3 are directed to restore the approval order dated and the appointment order dated in favor of the petitioner within 3 months. This is the order, Your Lordship.
Who are you?
Lordship, I am an aspirant for public employment, Your Lordship. I am also an aspirant for public employment, Your Lordship. So when there is a
You should have come to court at the right time.
Lordship,
So why,
this,
why you have not come to the court when the petition was pending?
Lordship, this the vacant post of the veterinary this post we came to know only later on, Your Lordship,
That's
because
not-
after the
that's-
judgment.
That's not an excuse. I mean, the case was going on. And the other thing is that like this is by way of court's order.
Yes, Your Lordship.
Court's order appointment has been made. How you are agreed by that? If you are agreed, then you should have
Lordship,
approached the court.
The judgment of the division bench did not say that to appoint the respondent number 4 in place of the petitioner, Lordship.
But it says that it has, because of this quashing of that, so that approval order is revived. That means what
No.
he is already.
The writ appeal, the judgment of the division bench does not say that those orders are revived. It does not say, my lord.
Let us see.
Lordship, yes, Your Lordship. Page 91, my lord. Page 91. Operative portion is from page 107.
Yes, which page?
94 is the judgment, my lord.
94.
Yes, lord. 91, 91. 91. We can read the type copy also. It's from 111 onwards. Type copy.
111?
Yes. Shall we do the whole judgment or only the operative portion, my lord?
Only let us see, I mean, how the operative part went. Para 13.
We can read from para
Wanted.
13 onwards.
12,
We can read from 13 onwards, my lord.
Yes,
12 or 13, 13.
13. The agreement dated 14 to 1972 would clearly indicate that the landowners of Sitimi village donated to the government of Nagaland their land, which is indicated in the sketch map for use by the government for Sitimi Circle Headquarters and other government departmental requirements. The agreement further indicates that the land donated is free from all encumbrances. No agreement was made with regard to the giving appointment on the basis of land ownership. Therefore, we are of the considered opinion that no right flows down to the landowners who have donated the land as per the agreement dated such and such to claim for any appointment on landowner basis for the lands donated by them free of cost. 14. The agreement dated would also indicate that the same has been made in the form of an affidavit, which also has not been sworn before the competent authority. We are therefore unable to accept the document dated 7/2/2009 either as an affidavit or as an agreement, and therefore the said document is it's honest in the eye of law. A consideration of the document dated would also indicate that the same is in contravention of the notification dated 26/7/2005, which clearly provides that no land shall be acquired free of cost and all land shall be acquired on payment of full compensation as determined by law, and that no further condition for employment in government service or awarding of contractual works should be entertained. Therefore, the respondent number 1 has no basis or locus to claim for appointment on the basis of land ownership to the post of medicine carrier at Animal Husbandry Center, Sitimi, under the establishment of District Veterinary Office, Kifri, on the basis of the document dated 7/2009. The notification dated 5/3/2018, which has already been reproduced herein above, also clearly indicates at clause 2 that all cases where administrative headquarters and block headquarters were set up in various parts of the state on lands donated freely by villagers, or people of that area should not be reopened for compensation or employment in consonance with the policy brought out by the memorandum dated such and such. We are of the considered opinion that the case of the respondent number 1 falls under clause 2 of the notification dated such and such. 16, Rule 11 and 12 of the Rules of Executive Business of the Government of Nagaland has also been considered, and on consideration of the same, we are of the opinion that the document dated, which is referred by the respondent number 1 as an agreement, cannot be considered as an order or instrument of the Government of Nagaland, and therefore the said document dated has no legal validity in the eye of the law. In view of what we have been discussed here in above, the judgment and order dated passed by the learned single judge in WPC 238K of 2011 and is set aside and quashed. Consequently, the order dated 28/11/2013, by which the respondent number 1 was appointed as medicine carer at Veterinary Health Center, Sitimi, under the establishment of District Veterinary and Animal Husbandry Office, Kifri, is also set aside and quashed. So this is the order, my lord.
Now, you were nowhere there in the scene, right?
Lordship?
You were nowhere there in the scene.
Yeah, I was not there,
You
lordship.
were nowhere there.
So what I'm saying is that
Subsequently, what happened? Subsequently, what?
so the post is vacant, your lordship. So what we are saying is what should have been followed was that the vacant post of maintenance care should be advertised.
Correct. So like now what has happened is that the other person has been appointed, right?
No one is, it's still vacant, my lord.
Still vacant.
Yes, still vacant, my lord.
Then
So now after this judgment, the writ petitioner again filed writ petition from which the incident appeal arises. His prayer was that now, since there is a judgment, now the respondent number private respondent's appointment should be cancelled, and then he should be appointed in place of respondent for in the post, your lordship. And the learned single judge has passed an order to appoint him in the post, your lordship. So what I'm saying is that there is an erroneous conclusion.
What was the basis of his claim
Lordship?
for appointment?
Lordship?
On what basis he was claiming appointment? In writ appeal, the private respondent's appointment was cancelled.
Yes, your
The
lordship.
private respondent was originally respondent number 4 in the writ petition.
Yes, your lordship.
So in writ appeal, the private respondent's appointment as medicine career was
Quashed.
quashed.
Yes, your lordship.
Now, by filing again a new writ petition,
Yes, your lordship.
the order again passed in which have been appealed in this
Yes, your
writ
lordship.
appeal.
Yes, my lord.
The petitioner is has sought for his appointment.
Yes, his
On what
appointment-
basis? On what basis? What was his basis of?
On his ground was that since the appointment of respondent number 4 has been quashed,
What
respondent number
was
4 is
claimed?
the ground taken by him was that the writ petitioner was that since since respondent number 4's appointment has been quashed, the earlier approval order, which was quashed, lordship, remember the first approval order
13-2.
6/10/2011, and the appointment order stands revived. Now the learned signature failed to consider that the appointment order was only for a period of 1 year, lordship. So what should have been followed is that in the scheme of constitution, a vacant post can only be filled up by following the due process, your lordship. Open advertisement where aspirants like me and others who wish to apply can participate, my lord. That is my case, your lordship. It has to be advertised. Directing that the writ petitioner should be appointed in place of respondent number 5 was wrong, your lordship.
No, now.
That one.
You'll have to show us that like what is wrong in the order, single judge's order.
Lordship,
Order single judge's order.
Lordship, in a single judge order, Lordship, there is the petitioner has been directed to be appointed in the post, your Lordship. So what I'm saying is that it was not through selection process appointment. His initial.
Have you applied for the post?
Lordship.
Did you apply for the post?
No, Lordship, it was not advertised at all. It was never advertised, my lord. It should be advertised so that everyone can participate. That's my case, my lord. I'm also one of in the state. Gainful employment in this in the public service is very scarce, your lordship. So any vacant post has to be advertised. That's my case, my lord. The conclusion that an illegal appointment set aside, revised, and another illegal order, lordship, that is also wrong, my lord.
You have not challenged that earlier order.
Which one, my lord?
The approval order, have you challenged that?
It has already been quashed, my lord. That was quashed already, and it was only for a period of.
But you were nowhere there.
Because I was not aware about this.
You'll have to be aware. I mean, nobody is going to make you aware. You'll have to know certain things.
Vacant post, only when it is advertised, we come to know, lordship. Only after the disposal of this writ appeals, we came to know that there is a vacant post of medicine career, lordship.
Yes, continue your submission. Anything else?
Yes, your lordship. So that is my case, your lordship. Since there is a vacant post of medicine career, it has to be advertised for all the eligible members to participate, your lordship. There has to be an open selection process, your lordship. It should be advertised. That's my case, my lord.
And is it your submission that learned single judge was wrong in holding that by mere quashing of the appointment of respondent number 1
Revives, yes.
revives
His earlier approval and
approval.
appointment order. Yes, your lordship.
Yes.
Our case is that what
Where is the approval order? That
approval order is page 40, my lord.
page 14.
40.
40.
13 is the writ petitioner, serial number 13.
This was also quashed by the single judge.
Yes, your lordship.
But appellate court did not make made any
Yes, yes,
discussion.
nothing, yes.
This was the whole thing was all appointments were paused.
Yes, your
Not
lordship.
only respect of.
Yes, your lordship, because during the time when the writ appeal was pending, your lordship, the private respondent was already appointed. Lordship. So that was quashed, your lordship.
No. What I'm asking is that, like, see, there are, 13 people who were appointed,
No,
approved.
yes, we only with regard to
That's what I'm asking. The whole thing was not quashed, only with respect of him.
yes, your lordship, only with respect of the item number 13, your lordship.
Where is that order?
Lordship,
Quashing this.
question, lordship. Page 60, my lord.
60.
Yes, ma'am. Operative portion, it's a page 88. Page 88 is operative portion. Para 37. Consequently, the order, as your lordship got it, page 88. Page 88. Para 37. Consequently, the order dated 6/10/2010, as far as approving the appointment of the private respondent as medicine carrier is concerned, as well as the order dated 14/2/12, appointing the said respondent as medicine carrier in the outpost veterinary office Kifri are set aside and quashed, my lord.
Who was the writ petitioner in that case?
this-
In that case.
Here, the respondent number 5. The respondent number 5. He challenged the approval,
Which respondent now filed?
the private respondent.
Private respondent where?
Private respondent in the writ petition, your lordship. In the writ petition, from which this instant appeal arises, and also he is the respondent number 5. in
There are
this
so
appeal.
many petitions. Which writ petition and which respondent number 5? What is his name?
Tovi Sema.
Yes, Atovi Singh, yes.
So where is that person now?
I'm appealing for private.
You're appealing for him?
Yes, Lordship. Because this writ petition started in 2010, Lordship, when the respondent number 1 in this writ appeal was appointed, the approval. I challenged the approval, saying that no, he has been appointed without any basis. So I challenged the appointment and I sought for an appointment on land ownership.
But that was also not given to you
No.
subsequently.
Subsequently, the writ appeal that was set aside.
That was set aside.
Yes, Lordship.
I have also made the writ petitioner a party, your lordship. He is respondent number 1 in this appeal, your lordship. He is respondent number 1 in this appeal, the writ petitioner, lordship. Today he's not there.
No, respondent number 5, Atovi Sema was not appointed.
No.
By the impugned order, it is respondent number 4.
Yes, my lord. The writ
Sri
petitioner
Alem
respondent.
Sangtham.
Yes.
He was appointed.
Yes, your lordship.
So
So
what is-
I challenge this appointment.
So you challenged this appointment, but it was not, it was your, argument. was
Initially,
taken.
the first writ petition, Lordship, was allowed. It was quashed and set aside, the approval.
Correct.
Now they file an appeal again. And then in the appeal, no mention has been made that he should be restored, but my claim also has gone on an ownership basis.
Yeah, that has been, gone.
Yes.
That has gone.
Yes. So both of us are writ petitioners at one point of time and private respondent. Now we are responding, both of us here. So the third appeal has come accordingly. That's how we've been arrayed as a party.
Now
because
by
we
the
were
By the impugned judgment, who has got benefit?
One, respondent number one. Alam Sankam.
Alim Sankam. Okay.
And very interestingly, Lordship, during the litigation,
Who-
both of us has become
Who is
operate.
representing him?
This is
One Mr. N.
N.
Longkuma was
Longkuma.
representing your lordship, but this morning he informed us that he's no longer appearing in this case, your lordship. It seems they
Then
have
someone
engaged
has to be
someone
there.
else. Yes, your lordship.
Who will defend him?
I don't know. I just spoke to him in the morning. He just said,
He should have told us, I mean, beforehand. Because without him, no, we cannot hear this matter.
Ultimately, he's the main
Yes.
he will be the main aggrieved person. Because the writ petition, the latest writ petition was
he informed
restoring.
that someone else has been appointed. So I was under the impression that someone will appear, your
No,
lordship.
but no, if somebody is not appearing, he should have mentioned us. We wasted our time.
Apologies, madam.
Isn't it? Because without him, because he is the main person.
Yes.
We'll adjourn this matter today.
Sure.
Let,
Yes, because he is the main party.
because
He's the main
if
party.
Somebody is
if
appearing.
this appeal is allowed, it is he who would be
Will
loser.
someone- We agree.
Yes.
Without hearing him, we cannot pass any order.
Because I'm not benefiting from this side or that side, Lordship. And in fact, both of us are overage now. If any advertisement has to be made, then we are not eligible, Lordship.
So you'll not,
That consideration has to be made for us. So because of the pendency of the litigations, more than 16 years, Lordship.
That is what I see, like third party. It is very limited. It can come before this court only with very limited grounds.
Lordship.
So you'll have to really convince the court that like you have some kind of right to come into this court.
Very true.
And without the person, they cannot be heard.
He's the main person.
He's also the main person.
Yes,
One of
my
this.
lord.
In fact, I should not have been at party also in this case, Lordship. I'm already out of the picture.
Yeah, you're there now.
I'm nowhere, Lordship.
Because your, whatever your grievances like, it has been met by the judgment.
Lordship.
third, Miss Easter. Learned counsel for the appellant. Also, Mr. Moaim Chen. Learned senior government counsel appearing for
Respondent 1, 2, 3, and 4. No, 3.
state respondent number 1,
2, 3, 4.
2,
1, 2, 3, 4. 1, 3, 4. 2, 3, 4. 2, 3, and 4.
One is the main aggrieved person, Lordship.
respondent number 2, 3, and 4. Also heard Mr. N. Muzoi appearing for respondent number 5.
5, Lordship.
Though this appeal is ready for hearing, however, today no one was found on call representing respondent number 1,
Lordship.
as the outcome of this appeal is going to affect the interest of respondent number 4 also. He is required to be heard. As such, the hearing is adjourned for the day. Let this matter be listed. When?
Lordship, next week, too many matters are listed, and after that, Justice Jungla will be there. So if it is matter listed after 3 weeks, my lord.
After 3 weeks on a date to be fixed by release.
Lordship.
Mr. Longkumar should have informed this court that
Yes.
he's
In
non,
fact, yes.
after 3 weeks on a date to be fixed by release.
Lordship. Deeply obliged, Lordship.
For hearing, item number 36.
May it please the lordship. Well, I'm sorry when I could not be present when the matter was called. I was in the midst of a matter in court number 5. My lord, the present appeal is directed against an order of the learned single judge, whereby, my lord, our writ petition was dismissed on 2 preliminary grounds. The learned single judge, my lord, did not advert to the merits of the case, the two grounds of dismissal was, my lord, one was there was a delay, and secondly, we lack locus standi. On two grounds, the writ petition was dismissed, and therefore we are before your lordships. Well, the matter relates to seniority in the grade of CP child, CDPO, my lord, Child Development Project Officer. Lord, before I take your lordships to the facts of the case, may I have your lordship's kind attention to this recruitment rules, which is at page number 36. If your lordships may kindly come to page 38. No facts are very bulky, my lord, but a very small point is involved.
Page number 38.
8, my lord. 3.1, Nagaland Social Security and Welfare Service, Class 1 gazetted, senior grade, we are not concerned. We are concerned with the junior grade. This grade shall include the post of Assistant Director and District Welfare Officer. Then, my lord, will kindly come to page 39 on top. Nagaland Social Security and Welfare Service, Class 2 gazetted. This is the post. This grade shall include all Class 2 gazetted posts such as Child Development Project Officer, Superintendent of Special Home, Research Officer, Provision Officer, Chief Instructor, etc. Now, if your lordship would kindly come to Rule 5, method of recruitment. Now, please come to 5.2, my lord.
Yes.
50% by direct recruitment and 50% by departmental promotion of lower grade in respect of CDPO and any other equivalent Class 2 gazetted post. So, my lord, as per this, the recruitment rules, the post in question falls in, my lord, 3.2, that is Class 2 gazetted, and, my lord, 50% of the posts are to be filled up by direct recruitment and 50% by promotion. Then, my lord, will kindly come to next page, Rule 6. As far as the appellants are concerned, my lord, they are promotees, so there is no difficulty. We have been promoted, there is absolutely no problem. Please come to Rule 6.2 at page 40. Subject to proviso of sub-rule 3 of Rule 5, wherever it is decided to fill a post or posts in any grade of the service by direct recruitment, the head of the department shall send a requisition in duplicate to the commission, that is Public Service Commission, through government in the form of a form prescribed by the commission. The commission shall advertise the post specifying the terms and conditions of the rule. So, my lord, as far as direct recruitment is concerned, it can only be filled up by selection, that it must be made by Public Service Commission. Now, our case in nutshell is, my lord, the private respondents number 4 to 8, they were initially appointed on contractual basis, that is a backdoor appointment, and subsequently they have been regularized. There is no scope of regularization under the rules. Supreme Court has said way back in 1979 that regularization is not a method of recruitment.
When they were regularized?
They were regularized, I'm giving the dates, my lord. My lord, they were regularized. Respondent number 4 was regularized on 11/3/15.
Yes.
Then, my lord, respondent number, sorry.
5.
Sorry, my lord. Respondent number 8 was regularized on 11/3/15. And 5, 6, and 7 were regularized on 26/9/16.
And four,
4 on, my lord, 11/3/15.
okay.
My lord, I think my instructing counsel has handed over the written argument, my lord. There the dates and pages are there. If your lordship kindly takes
Yes.
page 1, my lord, towards the bottom. Sorry, page 2, my lord. Roman 10 para that we have said, my lord. And the pages are also indicated.
Yes.
Now, as far as the, my lord, appellants are concerned, my lord, they were initially they were upgraded and subsequently, my lord, they were promoted. One second. If your lordship should kindly come to page 3 of the written argument, Roman 14, my lord.
Yes.
That in the meantime, a DPC for permanent upgradation of 60 number of supervisor class 3 to supervisor class 2 was held on 22/11/17, whereby recommendations were made to upgrade the services of the appellant as supervisor with effect from 26/9/16. Accordingly, the services of the appellants were upgraded as shown at serial number so and so. So, my lord, at page 192-94, it is there. Thereafter, my lord, a tentative seniority list of the class 2 gazetted officers under the Directorate of Social Welfare was published on 31/7/2018, my lord. In the said list, name of the appellants were placed below respondent number 4. That Roman 15, my lord. That a tentative seniority list of class 2 gazetted officers under the Directorate of Social Security and Welfare, Government of Nagaland, was published on 31/7/18. In the said list, names of appellants were placed below the respondent number 4. However, respondents number 5, 6, and 7 were placed below the appellants, and names of the respondent number 8, 9, and 10, and 11 did not figure in the said list, in as much as contract service of the respondent number 9 to 11 were not regularized. Then, my lord, eventually at page 4, Roman 17, my lord, an inter-se seniority list of class 1 and class 2 officers under directorate as on 1/3/2020 was published. On 23/2020, the name of the respondent number 4, 5, 6, and 7 appears as serial number 67 to 70, and appellants at 89 to 97, 100 to 100 to 104 to 16, and so and so respectively. So that on 15/9/22, DPC was held, whereby appellants were promoted to the cadre of CDPO to effect from 21/12/7/21, whereas appellant number 5 to 12/12 were promoted to the post of CDPO on 4/3/22. Now it so happened, my lord, in 2018, when the draft gradation list was published, it was only respondent number 4 who was shown above the petitioners, appellants, and rest were shown below the appellants. Now, eventually, my lord, we were also promoted as CDPO in the year 2022. Now, my lord, the most... Yes, my lord.
Yes.
Yes. Now we filed the writ petition, my lord, in 2019, August 2019. So where is the question of delay? There is no question of delay. Secondly, my lord, why we do not have locus standi? Because, my lord, a contractual employee is a backdoor entrant, and lordship knows, as per the rules, to become a member of service, you must be born in the cadre. My lord, lordship will kindly appreciate contractual appointment is always to a post. Whereas to get seniority, one must born in the cadre, he must born in the service.
The writ petition, what have you challenged?
In writ petition, we challenge the my lord, their appointments as well as the seniority list.
Their regularization,
Yes,
as well as the seniority list dated?
yes, my lord.
Which
Seniority
seniority
list dated, yes, I'm giving the date, my lord. Seniority list is dated 1 second, my lord. Just give me a second, my lord. Just give me a second, my lord.
Yes.
Is 23-2020.
No, my lord. Prior to that, I'm just giving it. Just now I got it. Page number, my lord, 170 of the writ appeal, 11/4/17. And thereafter on 31/7/18, my lord, page number 198 of the writ appeal. Page 198. Please come to page 199, my lord.
198 is tentative list.
Yes, tentative, first tentative. Then I filed the writ petition in 2019. Page 199 is the list. Serial number 5 is respondent number 4, my lord. Serial number 14 is appellant number 1. Serial number 15 is appellant number 2. 16 is 3. So similarly up to, my lord, serial 32. And serial number 36, 37, then 39, 41. These are all appellants, my lord. And my lord, the private respondents, if your lordship should kindly come to page 200. Serial number 62 is respondent number 6. Serial number 63 is respondent number 5. And serial number 64 is respondent number 7. Others, my lord, so we are basically against them. Others were not made senior above us. Thereafter, when the list was finalized, my lord, on 23/20, then all were shown above us. If your lordship should be, page 251, my lord.
251.
Yes. 251 to 250. I'm sorry, my lord. The list is at 52, 57. If your lordship should kindly come to page 261. Serial number 67 towards the bottom is respondent number 4. Serial number 68 is respondent number 6. Serial number 69 on page 262 on top, my lord, is respondent number 5. And serial number 70 is respondent number 7. And as far as appellants are concerned, They're from serial number 89 at page 263. 89 to 97 and 100 to 102, 104 to 106. 89 to 97 are appellants 1 to 9. Serial number 100 is appellant number 10. Serial number 101 is 11. Serial number 102 is 12. Serial number 104, 106 are appellant number 13, 14, and 15 respectively. And the writ petition was filed in 2019 after the tentative seniority list, my lord. So, my lord, the finding of the learned single judge that it is writ petition is belated, that is, my lord, in my humble submission is not correct. In any case, my lord, there is no limitation for approaching a 226 court. Supreme Court has said, my lord, that whenever a third party rights are created or where there is no explanation for the delay, then that those are fatal. But it is normally, my lord, in cases of this nature, to invoke the doctrine of delay in my humble submission is not a correct approach. Now, my lord, please come to their appointment orders. Then I formulate my point and, my lord, address your lordship. I'll just take another 15 minutes time. Now, please come to, my lord, page number. As far as we are concerned, my lord, we were initially appointed as supervisor in substantive capacity after our selection by the Public Service Commission. So there is no dispute. All the appellants were selected and appointed. Now, as far as the respondents are concerned, the lordship will kindly come to page number 114. Page number 114. This is the contractual appointment of respondent number 8 on 31/10/2008. The governor of Nagaland is pleased to appoint Ms. So-and-so to the post of Child Development Project Officer in the scale of pay of rupees so-and-so as admissible under the rules in force in Nagaland from time to time with effect from the date of joining the post. The appointment is made purely contractual basis for a period of 2 years or till the post is filled up by direct recruitment by NPSC. Then, my lord, page 116 is the appointment order of respondent number 4. Then, my lord, will kindly come to page number 110, 110. That is the ad hoc appointment of 4, 5, 6, and 7. 110. Governor of Nagaland is pleased to appoint following person to the post of child development in the so-and-so from the date of joining. The appointment is made on contract basis for a term of 1 year. So there is no dispute that the respondents were appointed on contract basis. Now, my lord, please come to page number 109, my lord. This is regularization order of respondent number 4. So there is no dispute that he was not selected by Public Service Commission as is mandated in the rules. 1 second, my lord. Then my lord will kindly come to page number 111. In the interest of public service, Governor of Nagaland is pleased to regularize the contract services of the following superintendent so-and-so under directorate of so-and-so in the pay scale of so-and-so plus other allowances as admissible under the rules in force in Nagaland from time to time with effect from 29/6/9/26. Now, my lord, though they were not made CDPOs, but they were made in the equivalent post of superintendent class 2 gazetted. So these are serial number 1 is respondent number 6, serial number 2 is respondent number 5, and serial number 3 is respondent number 7. Now, my lord, as far as the appellants are concerned, we were substantively promoted on 15/9/22, my lord, page 31 of the writ appeal. Page 31. A meeting of the Departmental Promotion Committee to consider the case for regularization of officiating promotion of officer under Social Welfare Department held on so-and-so in the conference of the Nagaland Public Service Commission. So, my lord, this is a duly constituted DPC headed by my lord, Chairman of the Nagaland Public Service Commission. Then serial number 3 is the appellant number 1. Similarly, my lord, up to serial number 11 is up to appellant number 9. Serial number 14 and 15 are 10 and 11. And my lord, serial number 16 is appellant number 12. So, my lord, now from factually what I have demonstrated is the private respondents were initially appointed on contractual basis. Thereafter, without following the rules, they were regularized. Their services were regularized. Whereas the appellants, my lord, they entered the service in class 3, supervisor. Then initially they were upgraded and eventually they were promoted. So now, therefore, all are in class 2 gazetted. Issue is who will become senior. Now, my lord, strictly speaking, their appointment itself is bad. That is not our prayer. Our prayer is only for setting aside the seniority list and remanding the matter to the back to the government. Now, my lord, I have already placed the rules. As far as direct recruitment is concerned, it can be done in terms of Rule 6, which I have already placed. And as promotion is concerned, it can be done under 5, which has been clearly done. Now, I'll just, my humble submission is very simple. To become a member of service, you must enter the service in accordance with rules. Because a contractual appointment can be made to a post, not to a cadre or service. I'll place that famous case of my lord, 1980.
What was the reasoning of the single judge while holding that? You are not audible. You are not audible.
My lord, the learned single judge does not discuss anything on merit. The
No,
learned
no.
single judge.
Listen to my
I'll-
question. While,
Yes,
while holding that the writ petition is barred by delay and laches,
yes.
what was the basis, what reasoning the learned single?
I'm placing it, my lord. It's a very short judgment. Page number 599. If your lordship should kindly come to 613. Para 16.
Yes.
It is an undisputed fact that all the petitioners were appointed as supervisors by various orders from the year 2003 up to 2008. What is to be noted is that they were appointed as direct recruits to the post of supervisor class 3 post gazetted in different batches. The private respondents were appointed as CDPO in class 2 from the year 2010 onwards. Schedule 2 of the rules of the 97 provides for supervisors to be eligible to be promoted to the post of CDPO and other equivalent posts requires 7 years of continuous service in that grade, provided the officers have undergone training in the respective matters. Further, Rule 5.2 provides for filling up the post of CDPO and any other equivalent class 2 post. The same shall be done by your 50% by direct recruitment and 50% by departmental promotion. In the case in hand, what is noticed is that if the petitioners are to be promoted to the post of CDPO, they will have to come under the 50. They are to come under 50% promotional quota. However, it is seen that the private respondents were appointed against direct recruitment, which becomes more evident by the fact that posts held by respondent 10 and 11 have been requisitioned to NPSC for filling up by direct recruitment. In view of the matter, this court is of the considered opinion that petitioners have no locus standi to challenge the appointment of private respondent by a present writ petition. Another important aspect of the matter is that challenge made to appointment of the private respondent at CDPO and other equivalent posts is made belatedly, and accordingly actions of the petitioners are hid by principles of delay, laches, and acquiescence. Lord, my humble submission is very simple, Lord. Here is a case. First of all, my Lord, you have to be, if you want to get seniority, first of all, you must be born in the cadre in accordance with the rules. Eventually, all have merged in the cadre of class 2 gazetted. Now, the dispute is who will be senior. Now, actually, my Lord, their appointment itself is wrong. They should be, actually, their services should be interfered with. Initially, this prayer was not made, therefore, today I cannot make it. So, my Lord, I'll place two case law from where from it will be clearly evident. How can a person become a member of service in order to claim seniority? And that is the famous judgment, my Lord, of State of UP versus Rafiquddin. 1987 Supplementary Supreme Court Cases 401, para 8.
Page.
It starts at page 401, my Lord.
401.
Yes, please come to page 411.
Don't have.
They have submitted two, but it's not that. They have submitted two judgment that was sent.
What is the citation? Please repeat the citation.
Yes, my Lord. 1987 Supplementary SCC 401. Para 8. At page 411.
Yes.
Yes.
It's
May I
in
read, my
written
Lord?
argument, Lordships. It's in the written arguments. The
The
citations.
citation. No, we are not talking about a citation. We are talking of the case.
Yes. After hearing the learned counsel for the parties at length and having given our anxious consideration to the controversy raised in these cases, we are of the opinion that the division bench completely misconceived the rules and rendered the judgment in total disregard to the facts available on record. As discussed earlier, rules entrust the Public Service Commission with duty of holding competitive examination and recommending names of suitable candidates have approved by it for appointment to the service on the basis of proficiency shown by the candidates at the examination, adjust on the basis of aggregate marks by them. Appointment to service is made from the list forwarded by the Commission to the state government. Seniority in this service is determined. Now, this is important, my lord, on the basis of the year of competitive examination, irrespective of the date of appointment, and interstate seniority of the candidate recruited to service is determined on the basis of their ranking in the merit list. So, my lord, it is quoted, my lord. Now, please come to that, my lord, last page, last line of the page. The aforesaid rule shows Commission was required to prepare a list of candidates approved by it for appointment to the service. Rule 19 provided that the list of selected candidates should be arranged in order of merit. Then, my lord, rule is preferred. Then please come to, my lord, last four lines of page 413. The expression such list in, I'm referring
before us.
You read slowly. We don't
I'm
have.
so-
the-
I'm so sorry, Bill. I'm so sorry, Milord. If I am permitted to read page 413, last four lines, Milord.
Yes, yes.
The expression such list in Rule 21 obviously refers to the list prepared by the Commission under Rule 19. It is therefore manifest that only those candidates can be appointed to service who are included in the list prepared by the Commission under Rule 19. If the Commission does not approve and include the name of a candidate in the list prepared by it under Rule 19, he cannot be appointed to the service under Rule 21. Rule 22 provides that the seniority in the service shall be determined by the year of competitive examination on the result of which a candidate is recruited and his position in the list prepared under Rule 19. The rule clearly postulates determination of seniority of member of this service recruited to service through competitive examination with reference to their position in the list of approved candidates prepared by the Commission under Rule 19. Now, this is very important, my lord. The expression of member of service as defined by Rule 4E means a person appointed in substantive capacity under the provisions of the rule. So who can become a member of service? Who is appointed in substantive capacity? That means it must be preceded by a selection by the Commission. Rule 22 read with Rule 4E lays down in unmistakable terms that seniority of a member of service is to be determined on the basis of year of competitive examination and not otherwise. In other words, only those persons who are appointed in accordance with rules on the result of competitive examination are entitled to determination of seniority in accordance with rule. I am on this, my lord. I am reading once again with your lordship's kind permission. In other words, only those persons who are appointed in accordance with the rules on the result of a competitive examination are entitled to determination of seniority in accordance with Rule 22. Seniority of a candidate appointed to service would depend upon the result of the competitive examination and his position in the list prepared under Rule 19. Claim to seniority under Rule 22 cannot be upheld if a candidate is not approved or appointed under Rule 19 and has not found his way into the service on the recommendation of the Commission. I'm reading it once again, my lord. Claim to seniority under Rule 22 cannot be upheld if a candidate is not approved for appointment under Rule 19 and has not found his way into the service on recommendation of the Commission. We therefore hold that claim of seniority on the basis of year of competitive examination as contemplated by Rule 22 is available only to those candidates who are approved by the Commission on the basis of their marks in the written examination, viva voce test and examination. So my humble understanding, my lord, subject to what your lordships may say, is very simple. If a person becomes a member of service following due selection by either by the commission or by the selection committee as prescribed in the rules, he alone is entitled to determination of seniority. A contractual employee, my lord, who is a backdoor entry, there is no question of regularization. Like, as far as promotee is concerned, like us, we can come into the picture only by virtue of Rule 5.2. And as far as direct recruit, like the private respondents are concerned, they can come into the picture only by the route of Rule 6.2, that is selection by the commission. Here in the instant case, admitted position is they are contractual appointees subsequently regularized. So therefore, my lord, they cannot claim seniority over us. End of the day, we also travel to that class 2 gazetted. They're already in class 2 gazetted. Therefore, my lord, there's no question of counting their seniority vis-a-vis the appellant. Well, this is my basic case, my lord. Now,
No.
in this factual,
Have you challenged regularization?
one second, my lord. No, my lord. Now, yes. Now, here in this case, my lord, even if the Supreme Court says, though their appointment would be saved, but they are not entitled to seniority, that paragraph I'm placing. Please come to para 22, my lord. Even that point is also decided.
Yes.
Please come to para 21.
Yes, read slowly.
Yes. Now the question arises as to what seniority should be assigned to the unplaced candidates. Their claim for seniority, their claim for assigning them seniority on the basis of competitive examination of 70 is not sustainable in law as discussed above. They were appointed to service after 5 years of the examination, and before their appointment, competitive examination of 72 had taken place, and candidates selected under that examination had been appointed to the service prior to their appointment. In this case, it so happened, my lord, in Rafiquddin's case, the 1970 batch were appointed subsequently. Before that, the 72 batch were appointed. The direction issued by the High Court for rearranging the merit list of 70 examination seriously affected the seniority of those who were regularly selected in accordance with norms prescribed by the Commission. Having regard to these facts and circumstances of the case, we are of the opinion that the view taken by the High Court on the administrative side that the state government that unplaced candidate of 70 examination should be assigned seniority below the last candidate of 1972 examination appointed to service is just and reasonable. In our opinion, it would be just and proper to assign seniority to unplaced candidates of 70 examination at the bottom of the list of 1972. There were 37 unplaced candidates of 70 examinations who were included in 3 lists. Out of them, 16 candidates appeared in 72 examination and they were successful and their names were approved by the Commission in the list prepared under Rule 19. The state government appointed them in service under Rule 22 and they are entitled to seniority. They are entitled to seniority of 72 examination, but we have already recorded findings that the unplaced candidates of 70 examination have not been recruited in service. According to the rules, their recruitment to service cannot be treated under 70 examination for the purpose of determining seniority under Rule 22. We have further directed that 20 unplaced candidates of 70 examination should be placed below the candidates of 1972 examination. So far as the 16 remaining candidates are concerned, they were appointed to this service on the basis of result of 72 examination, and their appointment does not suffer from any legal infirmity. They are therefore entitled to seniority of 72 examination on the basis of their position in the merit list of the examination. They were, however, not entitled to seniority of 70 on the basis of examination of that year held by the High Court. We accordingly set aside the order of the division bench dated so and so, direct the High Court and the state government to determine seniority of the 21 unplaced candidates of 70 examination by placing them at the bottom of the candidates appointed on the result of 72 examination. We accordingly allow the civil appeal. Now, my lord, will kindly come to para 28, my lord.
Yes.
Now, please come to Milord. We do not find merit in either of the two submission. Rule 22 lays down criteria for determination of seniority of members of service. It directs that seniority shall be determined on the basis of the year of examination, which means that a person recruited to the service in pursuance of result of the particular year of examination would rank senior to the candidate who is recruited to the service in pursuant to the result of a subsequent year. Who is a recruited service of the year of the exam, although he may have actually been appointed earlier in point of time. Kindly mark this. After selection of candidates, several formalities are followed before appointment is made under Rule 21. The selected candidates are required to undergo medical examination. Their character and antecedents are verified, and approval of the High Court is obtained, and only thereafter the governor appoints them by issuing notification. Many a time this process causes delay in making the actual appointment, and in that process, sometimes persons selected on the basis of subsequent examination are appointed before the successful candidates of earlier examinations are appointed. But in view of Rule 22, the latter shall be senior to the former, irrespective of the date of appointment. Since there has been no challenge to Rule 22, an appointment is not shown to be legal for the reasons which we presently give, it must be applied in its plain term in determining seniority of those recruited to service in accordance with the rules. Petitioner was appointed in service on the basis of result of 73 examination, while respondent 3 to 15 were recruited to the service on the basis of result of 72 examination. Therefore, according to Rule 22, respondents 3 to 15 are entitled to be senior to the petitioner. In mere fact that petitioners were appointed few months before respondent number 3 to 15 are appointed cannot override the express provisions of Rule 22. Now, in this case, it so happened, my lord, the persons who were appointed earlier, there were some formalities left to be completed. But insofar as the, my lord, these 21 were concerned, they were regularly selected, everything was done, they were appointed. In terms of Rule 22, the seniority was given. Now, going by the ratio laid down in paragraph 8, my humble submission is, my lord, this respondents, private respondents, they were contractual appointees and subsequently their services were regularized. Now, I have demonstrated from the rules, my lord, there is no provision for regularization. Rule 6.2 mandates only direct recruitment, that too by Public Service Commission. If somebody enters this service other than by way of a selection by Public Service Commission, my lord, strictly speaking, he cannot even become member of service.
No, have you managed their regularization?
Yes, my lord. I'll place the writ petition, my lord. I think the writ petition is at, my lord, page number 59.
They were regularized in the year 2015-16.
50, starting 15, my lord. Please come to page 93, my lord. In fact, the first prayer is regularization order. Prayer 2 is regularization. Prayer 3 is regularization. Then prayer 4 are appointment on extension. So, my lord, we have challenged everything, including the seniority list. My lord, on the point of delay, I would like to place one constitution bench judgment, my lord. That is 1974, 1 SCC 317. Ramchandra Shankar Devdhar versus State of Maharashtra. Here there was delay of 15 years, my lord. It was a case of Article 32, my lord. Please have the judgment, my lord. 1974, 1 SCC 317.
You have a copy of that judgment?
Yes.
Send only to citations. So I submitted that. The
Okay. Yes, what is the, what is the?
Follow otherwise, it becomes
Yes,
very
yes.
difficult.
So I beg your pardon.
I think they must have.
They have not provided, but you can say, submit what is there.
Can I read it slowly, my lord?
Yes.
Yes. There was a delay of more than 10 or 12 years in filing petition since accrual of the cause of complaint, and this delay contended the respondent was sufficient to disentitle the petitioners to any relief in a petition under Article 32 of the Constitution. We do not think this contention should prevail with us. In the first place, it must be remembered the rule which says court may not inquire into belated and stale claim is not a rule of law, but a rule of practice based on sound and proper exercise of discretion. And there is no inviolable rule that whenever there is delay, the court must necessarily refuse to entertain the petition. Each case must depend on its own facts. The question, as pointed out by Hidayatullah Chief Justice in Tilok Chand Motichand, is one of discretion for this court to follow from case to case. There is no lower limit and there is no upper limit. It will depend on what the breaches of fundamental right and remedy claimed are and how the delay arose. So, my lord, so this is the proposition laid down by Constitution bench. My lord, 226 Court Limitation Act does not apply. However, my lord, it has been the established practice, my lord, that normally a person should approach the court of law when the cause of action is fresh. In other words, my lord, in the meantime, if any third party right is created, then also, my lord, Supreme Court says it is not a bar, but there ought to be some explanation. Here in this case, my lord, the moment, my lord, the tentative seniority list was published in March 2018, we filed the writ petition in August 2019. After filing of the writ petition, the seniority list was finalized. So therefore, to construe that there is delay and therefore it will be fatal, in my humble submission, may not be correct. My lord, I'll rely upon two other authorities, my lord, on the point that how I think my learned friend must be ready with the judgment of 1992 supplementary 1 SCC 272. (1992) supplementary 1 SCC 272 Keshav Chandra Misra Joshi, para 19, my lord, at page 282. My lord, humble understanding of mine is, my lord, these two judgments are viable as far as seniority aspect is concerned. Rafiquddin and Lord Keshav Joshi. Please come to para 19, Placidum B, my lord.
Yes.
In order to become a member of the service, has your lordship got it, my lord?
Yes.
In order to become a member of service, they must satisfy two conditions. Namely, the appointment must be in a substantive capacity, and appointment has to be to the post in service according to rules and within the quota to a substantive vacancy. There exists a marked distinction between an appointment in a substantive capacity and appointment to a substantive post. Therefore, the membership to service must be preceded by an order of appointment to the post validly made by the governor. Then only they become member of the service. Any other construction would violate the rules. Then please come to para 23, my lord. Please come to, my lord, placitum F and G, between placitum F and G.
Yes.
Employees appointed purely on ad hoc or officiating basis due to administrative exigency, even though continued for a long spell, do not become member of service unless governor appoints them in accordance with the rules, and they are not entitled to count their entire length of continuous officiation or fortuitous service towards their seniority. So this is the ultimate nail in the coffin. So a contractual employee, he cannot claim any, seniority for the fortuitous period. On this point, my lord, there is one more judgment, my lord. 2009, 12 SCC 49. Para 18. 2009, 12 SCC 49. Para 18 at page 57.
Yes.
In order to become a member of service, a candidate must satisfy 4 conditions, namely, the appointment must be in a substantive capacity, to a post in this service in a substantive vacancy made according to rules within the quota prescribed for the source. Improvement, then within the quota. Ad hoc appointment is always to a post, but not to a cadre and service, and is also not made in accordance with the provisions contained in the recruitment rules for regular appointment. Although the adjective regular was not used before the word appointment in the existing cadre service in para 3 of the geodated so-and-so, which provided for selection pay scale, the appointment mentioned there is obviously a need for regular appointment made in accordance with the recruitment rule. What was implicit in said paragraph of government order when it refers to appointment to a cadre service has been made explicit by clarification dated. So, my lord, 4 conditions which is required. My lord, seniority is a consequential aspect. First, an incumbent who claims seniority in a cadre or a service, he must first establish that he entered the cadre in accordance with rules. If he cannot satisfy that he entered the service in accordance with rules, then well, there is no question of conferring seniority upon those persons. First, appointment must.
What happens if their services are regularized and the regularization remain unchallenged?
No, my lord, the regularization may save their appointment, but not their seniority. I think, my lord, what follows from the decision in the ratio in Rafiquddin is, my lord, appointment would be saved, but not the seniority. In any case, my lord, their appointments are not under challenge. Question is, it's a seniority dispute, my lord. It is not a case where we are saying that their appointments should be set aside. Even if they are regularized, my lord, since their regularization is not a concept which is envisaged in the rules. It's an out and out illegality, my lord.
So at what place they will be in the seniority list?
No, they should be below us. As far as we are concerned, actually they should be bottom of the list, my lord.
At all point of time.
Yes, because they never entered the service class 2 gazetted service in accordance with rules. All point of time they will remain in the bottom of the list.
Okay.
So therefore, my humble submission is, my lord, the learned single judge should have, my lord, decided the case on merit. Instead, learned single judge has chosen to, take up the matter on the 2 preliminary point and dismiss the writ petition, which in my humble submission was not a correct approach, my lord. Because here is a case, at least, my lord, we were doing a service. We expect in life to climb the ladder. And we can climb the ladder only by our promotion. We have earned our promotion. Now, while we got our promotion, we have seen people who are loitering in the cadre without they being selected in accordance with rules. And they have been ranked senior to us.
Okay,
So it's a violation.
Why the single judge held that you don't have locus standi?
Because, my lord, according to the learned single judge, we were promotees and that was a case of direct recruitment, as is evident from para 16. But learned single judge has not taken note of the fact, eventually we all merged in class 2 gazetted, following our upgradation and promotion. And as far as our initial recruitment, promotion, these are all in accordance with the rules.
And the seniority list was a common seniority list for.
Yes. That seniority list I have already placed, my lord. First one is at page number
199.
31/7/18, page 198. 197, it starts, my lord. Tentative seniority list.
Yes.
So therefore, my humble submission is, my lord, the learned single judge has committed an error of law in dismissing our writ petition. There are 2 ways, my lord. Either your lordships may remand the matter to the learned single judge to decide the case on merit, or lordships may decide the case on merit.
Yes.
And in the event lordship accepts our case, my lord, then the prayer at page 193, page 93 and 94 should be allowed, my lord. My lord, there are other authorities. I am not troubling your lordship much with this, my lord.
Okay.
I feel, my lord, these are sufficient materials for adjudication of the issue.
Yes,
That is my humble submission. And, my lord, I have placed a written argument. There I have also indicated my argument. I think it must be handed over. I think my junior colleague has, yes. If your lordships are for a moment, my lord, for a moment, please permit me to place para 6 of my written argument, my lord. Roman 3 and 4.
Yes.
For that on the teeth of the recruitment rules, which do not provide any provision for contractual appointment and regularization, the stand of the government of Nagaland that appellants are promoted and the respondents 4 to 11 are direct recruits, and therefore appellants have no locus standi to challenge the interstate seniority list, an argument seemingly accepted by the learned single judge is clearly unsustainable in the facts and circumstances of the instant case. For that the recruitment rule having provided for direct recruitment and promotion, respondents 4 to 11 and more particularly response 4 to 8 who are backdoor entrants and whose services have been illegally regularized in contravention of the recruitment rule, respondent number 4 to 8 cannot be placed above the appellants in the inter-se seniority list of the CDPO. It is a settled position of law that in order to become a member of service, CDPO in the present case, one must be born in the cadre according to the rules. Regularization being not a mode of recruitment, confirmation of seniority to respond for over appellants in the cadre of CDPO is wholly unjust, untenable, and in this regard, the appellant would like to refer and rely upon the following authorities. The other principal contention arrived at conclusion arrived at by the single judge that writ petition is hit by delay and latches is also flawed and hence is unsustainable. The constitution bench of the apex court in Ramchandra Shankar Deodhar versus State of Maharashtra reported in so and so at paragraph 10 observed that the rule which says that court may not inquire into belated claim is not a rule of law, but a rule of practice based on sound and proper exercise of discretion. And there is no inviolable rule that when there is a delay, the court must necessarily refuse to entertain the petition. So I have also, my lord, narrated the grounds of my challenge in my written argument. So in that view of the matter, my lord, the writ petition should be allowed, my lord. The writ appeal and the writ petition should be allowed.
Yes.
That is my humble submission.
Maybe so, Lordship.
Mr. Musa, you are for.
I'm for respondent number 2 and 3, Lordship, the department. Secretary, Department of Social Security and Welfare, and the Director, 2 and 3.
Yes.
Lordship, as fairly admitted by the appellant, they are not challenging the regularization, firstly, Lordship.
No, we are challenging. In fact, the prayer says.
But as submitted, Lordship.
No. I pointed out to the honorable court.
No, Lordship, the regular.
I'm sorry to interrupt. We say that we have not challenged their appointments.
Fine. Lordship, may kindly make a clear distinction here. The appellants are in a low grade, in the rank of supervisor, that was subsequently upgraded to senior supervisor. The respondents are in a high grade, Lordship, CDPO. So how are the appellants aggrieved as far as seniority is concerned, Lordship? No doubt a challenge was made that has not been interfered with, Lordship.
They have spent sufficient time there, so there is one seniority list only.
Yes, Lordship.
So
now, as far as the contentions raised, Lordship, by the appellants, when these two categories, they are in 2 different grades, Lordship. How are they aggrieved, Lordship? They are not in the same category that I should be placed senior above, Lordship, on the number of decisions that has been placed by my learned senior counsel, Lordship.
No, the seniority list pertains to class 2 gazetted officers.
Lordship. That was it was subsequently upgraded, Lordship. Senior supervisor.
Whatever, it was upgraded and now the position is that they are in the same select list. I mean, same grade. And that's why there's a one seniority list.
Lordship.
And one seniority list, they are agreed by certain positioning.
Lordship.
About the seniority. That's why they have come to the court. Now that argument that he is lower in the thing, that may not be very convincing.
Lordship. But as far as the stand of the state is concerned, Lordship, they are not aggrieved. That's the stand of the government, Lordship. They are not aggrieved, Lordship, because they are in 2 different categories. And the decision is taken by the cabinet, Lordship, for regularization.
But is there any statutory backing for regularization?
Lordship, the law is very clear on that, Lordship. I will not be commenting on that, Lordship. But the decision was taken by the cabinet, Lordship. They have been working. It's not denied that they've been. Yes, Lordship. They have been.
Have you placed before this court, cabinet decision?
Lordship, yes. I have stated in my affidavit, Lordship. Lordship, may kindly come to page 301. That's my affidavit, Lordship.
301.
Of the appeal memo, Lordship.
Lordship, may I kindly come to paragraph 6, starting from paragraph 6, Lordship. Am I allowed to read, Lordship?
Yes.
Paragraph 6, page 303, Lordship. That with regard to the statement made in paragraph so and so, the answering department begs to state that the private respondent number 5, 6, and 7 were initially appointed as child development project officer on contract basis. However, they were subsequently regularized by order dated 17/10/2016 as research officer, superintendent, special home and observation home, Perima, and chief instructor, Angamodi Center, Dipupar. Mention be made that the post of research officer, superintendent, special home and observation home, chief instructor, Angamodi Training Center are equivalent to the post of CDPO and are transfer posts as per the Nagaland Social Security Welfare Services Revised Rule 1997. With regard to the statement made in paragraph so and so of the petition, the upgradation of CDPO Class 2 under ICDS to that of CDPO Class 1 was notified by notification dated 21/9/2012 for the regular post in the department. However, the respondent during that point of time, though they were not holding the post of CDPO, which is a Class 2 gazette, Class 2, were not considered for upgradation as they were still under contract basis and yet to be regularized. That with regard to the statement made in paragraph so and so of the petition, the answering department begs to state that upon consideration of all representation and a cadre strand, the department by letter number so and so dated 15/4/2019 proposed a new cadre review and service rule 2019. Accordingly, a cadre review committee was being constituted and put up to the government. Hence, the proposed cadre review and service rule is still pending at the government level for consideration. That with regard to the statement made in paragraph 14 of the petition, the answering department begs to state that with regard to the respondent 10 and 11, they are still serving in contract basis. As well as dated 17/2/2015.
Where is the cabinet decision?
Lordship, the cabinet decision has been annexed by the petitioners in the writ petition.
Which page?
Lordship, I'll get to that, Lordship. Give me a minute. Writ petition, writ petition.
Let us see how they have been regularized.
Lordship. Take 83. 83. City upgradation is resolution, cabinet member also, regulation, cabinet member.
Is it page 209?
Lordship, I'm coming to that.
209, just check.
209, should be yes. Because there are so many cabinet decisions, because cabinet review also went. There are so many cabinet decisions, Lordship, but there. 209. 3rd May 2019.
Even if there is a cabinet decision, will it override the statutory?
212.
I think it is at page 210, my lord.
212, Lordship.
No.
209
Cabinet.
memo, Lordship, yes.
My lord, page 210, towards the bottom, agenda number 5.
Agenda number 5, yes. Accordingly, page 212 notification has been issued, Lordship, on the recommendation of the cabinet. Another copy. No? 212 and 213, Lordship. It's not legible, Lordship.
No, what is your response to the submissions made by the counsel for the appellant that the appointment were not as per rules?
Lordship, yes.
Appointment of private respondents.
We have not denied that fact, Lordship. They were in contract basis and they were subsequently regularized. I've already stated in my affidavit also, Lordship. They were initially appointed on contract basis, but subsequently recognized by the cabinet, Lordship.
So they will have to be placed below the persons who are recruited as per rules. What is your response?
Lordship, I leave to the wisdom of this court, Lordship, because as far as my part is concerned, Lordship, I'm not denying that fact. They were initially appointed on contract basis, but subsequently recognized.
Okay.
In the cabinet, there was one line written there. I don't know what.
The committee will determine the seniority.
Yes.
Yes,
What is
Lordship.
that?
Lordship, as per the cabinet memo, Lordship, the department is to constitute a committee for determination of the seniority.
Have you done?
Lordship, that I don't have the record with me, Lordship. I don't have the record with me.
Okay.
In my fair submission, Lordship, I don't have the report as far as the committee is concerned, Lordship.
My lord, to reply to my learned friend, my lord, I just place one paragraph from one decision and that will conclude, my lord. I think my friend will forward that copy, 1979, 4 SCC 507. 1979, 4 SCC 507. Para 24 and 25. This is a judgment for the proposition, my lord. 1. Regularization is not a mode of recruitment. 2. By exercising power under Article 162, Cabinet cannot override a 309 rules. Please have page 514. Para 24 at page 514.
Yes.
In so-and-so, also question of regularization of an appointment arose, and this court dealt with thus. Counsel on behalf of the respondent contended that regularization would mean conferring the quality of permanence on appointment, whereas counsel on behalf of the state contended that regularization did not mean permanence, but it was a case of regularization of rules under 309. Both the contentions are fallacious. If the appointment itself is in infraction of the rule, or if it is in violation of the provisions of the Constitution, illegality cannot be regularized. Rectification or regularization is possible of an act which is within the power and province of the authority, but there has been some non-compliance with the procedure or manner which does not go to the root of the appointment. Regularization cannot be said to be a mode of recruitment. This is very important. To accede to such a proposition would be to introduce a new head of appointment in defiance of rules, or it may have the effect of setting at naught the rules. Apart from repelling the contention that regularization connotes permanence, these observations furnish the second reason for rejection of the argument advanced on behalf of the promotees. And that reason is that when rules framed under Article 309 of India are in force, no regularization is permissible in exercise of executive power of the government under Article 132 thereof in contravention of the rules. So, my lord, this is a very fairly well settled proposition of law. The exercise of regularization is nothing. It is an executive fiat which state can exercise under Article 162. And the Supreme Court says, my lord, when there is a recruitment rule which prescribes a particular procedure of selection, it cannot be deviated from. Therefore, number one, regularization is not a mode of recruitment. And secondly, my lord, what do we call it? By invoking Article 162 powers, the rigors of the rules cannot be, my lord, whittled down. Therefore, my lord, the state's contention, of course, my friend has very fairly submitted, but then, my lord, end of the day, state had resorted to all this favoritism. Therefore, my humble submission is now Lordships will set it not the illegalities which has been caused to the Milord appellants. That's my humble submission.
Yes, Mr. Iralu.
Lordship,
You-
just one
you-
clarification to the query made by the Lordship regarding the committee. There was a stay order because a notification was issued on page 213, Lordship, 213. 11 June 2019. Where in the bottom, with regard to the seniority, determination of seniority, this was stayed. So the committee could not decide. The query of the court, Lordship.
Okay.
May it please your lordships. At the outset, I would like to clarify that the present appellants, they were initially appointed as class 3 non-gazetted supervisors. And that was between 2003 and 2008. Then subsequently, out of the several posts of supervisors, 60 were upgraded to class 2 gazetted. Now, while they were serving as class 2 gazetted, this read petition was filed. And during the pendency of the read petition, 12 of them in this appeal memo from 1 to 12, they were promoted to the post of CDPO. And that was during pendency of the petition. Then subsequently, the rest, they were promoted to the post of CDPO subsequently. Now they are all serving as CDPO. Because during pendency of the petition as well as the read appeal, they were all promoted. And one of the prayer of the appellants is for promotion to the post of CDPO.
That is already done.
Yes, that is already done. So now,
the
your
question
lordship,
is of the seniority.
your lordship seniority, when they were serving as class 3 supervisors, we were appointed on contract basis in terms of the guidelines of the department issued by the government of India. We were appointed on contract. And we were appointed against direct recruit quota. And so, your lordship knows very well that when there is quota rule, then a direct recruit, a person cannot be appointed against a promoted quota. And a promotee cannot be promoted against a direct quota. They have to go by their own quota. Therefore, what the learner single just says is that yes, there is 50-50 quota, and these petitioners, appellants, since they were promotees, they cannot claim the quota of the
No, that
direct
question,
recruits. So they have
that
no
question regarding promotion does not survive because they already got promotion.
No, at that point of time, when that was decided, they were yet to be promoted. They were serving as upgraded senior supervisors. 60 posts were upgraded.
Their main
2012.
contention is that your appointment was
Your lordship,
not as per rules.
your lordship, not as per the present social welfare rules, but the learner single child also has mentioned, as we have mentioned in our petition, that there is a scheme, ICDS scheme. Now contract appointment can be made. So taking that we were appointed against direct recruit quotas. And subsequently we were regularized by undergoing a suitability test. Because there's a notification.
Is there any provision like that in the rule?
Yes.
Where?
By,
shows the- so where it
by
is
a
done.
subsequent notification, not under the book.
So the rule where, I mean, you have a statute there.
Uh,
Whether you have been appointed as per the statute,
that
or
is-
that you have to say.
That is issued by the state government.
See, the learned senior counsel for the appellant has argued 3-4 specific arguments, right, submission. So you need to meet those arguments.
Your Lordship, in my humble opinion, now in our written objection to the petition, we have raised many objections, but the court has come to the conclusion, one, that the petitioners have no locus standi. And the second one is that there is delay and legislation. Now,
Mr. Iralo,
the question is,
legal judge has not gone into the merits of the matter. He hasn't. He has preliminarily discussed certain things because he need to lay the facts. But other than that, he has not discussed the merit of the matter. He has dismissed the petition on 2 grounds: delay and legislation, saying that these people do not have
Your Lordship, that also is correct. Therefore, now, Your Lordship, first, what the appellants has to do is that they have to challenge the findings of the learned single judge that we have locus standi. The court says you have no locus standi. Now, they have partially questioned that one. More or less, they are admitted about the locus standi. They have not said anything about that these respondents were appointed against the recruit quota, and that these persons, appellants or petitioners, they will be promoted against promotees quota. That they have not denied. Then the second point is delay and lectures. Now, in our reply to the petition, we have specifically stated that there is delay and lectures. And Your Lordship, in their reply to our affidavit, Your Lordship will see at page Four 43, I think. Our objection to the delay and lectures is mentioned at paragraph 6 of our affidavit in reply.
Page.
In our affidavit 463. Paragraph 6, 6162.
Page number?
Page number 463.
463.
Yes. And their reply against our objection is what? Beginning from 443, that is affidavit in reply. And the relevant paragraph is at page 449. paragraph 13. I'm sorry. Page 448. Reply paragraph 12. May I read, Lordship?
Yes.
That with regard to the statements made in paragraph 6, 6.1, and 6.2 of the affidavit in opposition of the respondents number 5, 6, and 7, raising objection vis-a-vis seniority of the respondents, claiming the petitioners not having locus standi to question the seniority of the respondents. The petitioners, while reiterating the above paragraphs, in particular paragraph 6 and 11, rest assured that the respondents have admitted that their seniority is counted from the date of cabinet approval on 6/5/2019, and their emphasis on seniority need no corroboration when an issue in law has defeated the respondents by the Nagaland Social Security and Welfare Service Rules revised 1997 and Law of Land. So they are admitting about the detailed ledgers. They have not denied. And the learned single judge in paragraph 1, 2, 3 of the impugned judgment has clearly stated when they were appointed, when we were appointed, when regularized, and taking cognizance of that the court has come to the conclusion that there is delay. Now, in this appeal memo, what did they say about the delay? Your Lordship may kindly come to ground M, page 27. They said nothing. Paragraph M, further, the learned single judge has failed to appreciate that the contractual appointments as well as the subsequent regularization of the private respondents are without any authority of law. As such, their appointments are void ab initio. In spite of the same, they have been assigned seniority over the appellants in the grade of CDPO in violation of Article 16 of the Constitution of India. It is a tried law that fundamental rights guaranteed under Article 16 cannot be wished away solely on the jejune ground of delay. Therefore, the impugned finding of the learned single judge that the writ petition is barred by the principles of delay, ledges, and acquiescence is liable to be interfered with at the hands of this honorable court. In the ultimate analysis, the conditions of service of the appellants stood violated as the appointment and regularization of respondent number 4 to 11 affected the seniority of the appellants in the cadre of CTPO. Now, in the cadre of this is the reply to this is their grounds of challenge to the delay is this. Yes, there is no specific time fix for filing in the writ petition, but Your Lordship knows better. It is well settled that the party who he cannot take advantage of his own action by delaying his matter. Delay defeats justice also. And then about the CDPO. Now, during the pendency of this petition and writ appeal, they were promoted to the post of CDPO. Then, Your Lordship, let me again go to the seniority list of Class 2 Gazetted, which the appellants are relying at page page 199. starting from 198, Your Lordship. This is a proposed seniority list only. This is not a circulated seniority list to the employees. From page 198. This is from additional director to the secretary. Madam, would subject submission of tentative seniority list of class 2 gazetted officers under Directorate of Social Welfare. Madam, with reference to your letter number so dated Kohima, the 10 July 2018, I am directed to submit.
Subsequent to this, there is a final seniority list in CDPO.
Yes, there is. But after this proposed seniority list, because if it is a tentative seniority list, then it should have been circulated amongst the employees to put in for objections.
Correct. So you are saying that this was a tentative seniority list and they have challenged this only.
No. They are relying on this one in the grade of class 2.
Correct.
Because at this point of time, when we were appointed as CDPO initially, now CDPO is class 1 gazetted.
Correct.
I'm sorry.
Class 2
gazetted.
Class 2 gazetted.
And supervisor is class 3
But they were
non-gazetted.
upgraded later.
Then after this, during the course of time, all the posts of CDPOs were upgraded to class 1. Now at that point of time, we were also holding the post of CDPO on contract, but our posts were excluded, including probation officers and other 3 posts.
You were excluded for
It was excluded.
Excluded for?
They were all class 2 gazetted, but they have not been upgraded to class 1. Whereas some of the rest of the posts of CDPOs were upgraded to class 1. During that point of time, before the other
Class
posts,
1.
class 1.
Now all CDPOs are in class 1.
Class 1, yes. Then,
Including the appellants.
including the appellants. And now there is a proposed amendment of the service rules, but I think that is still not yet finalized. And in the prayer, your lordship will see, in 2016, they are also praying for that one. But that is yet to be finalized, I believe. Now, when this was going on, this preparation of the seniority of class 2 gazetted, the post of other class 2 gazetted officers were upgraded to class 1, including our post. But at that point of time, we were transferred and we were holding the post of class 2 gazetted, but not CDPO. But all those were upgraded to class 1. Subsequently, we were appointed against those upgraded posts of class 1 gazetted. And at that point of time, these appellants, petitioners, they are all class 2. They were all class 2 gazetted because they were upgraded to senior supervisors. Only recently, 2023 and 4, 5, they were promoted to CDPO, class 1.
But as per rules, CDPO is within class 2 gazetted posts.
Initially class 2.
No, but as per existing rules.
It must have been upgraded because as per the new rules also, it must have been made class 1. Because now by the government has upgraded all the earlier class 2 posts to class 1 post, class 1 gazette.
I have mentioned that in my paragraph 7, page 303. The
Is there
upgrade.
amendment?
The notification issued, Lordship, but the service rule was not amended. But there's a notification.
Notification has been issued, but the
Yes,
service rule is yet to be amended.
21/9/2012. It was upgraded from grade class 2 to class 1.
But there is no dispute in that.
Now, Your Lordship, one fact is when they were serving as supervisors, class 3, non-gazetted, they demand for upgradation of that to class 2. And we, as class 2, holding class 2 gazetted, we also demand for upgradation of those posts which the government excluded, or 5 posts. 5 posts. Because prior to that, government has upgraded all the CDPO to class 1. Subsequently, the cabinet has approved the upgradation. And accordingly, we were accommodated against those upgraded posts. And many of these supervisors were having upgraded the post to senior supervisors, they were also accommodated in the class 2 senior supervisor.
Some different nomenclature like research officer or something like that, which are equivalent to CDPOs.
And we filed a petition, Your Lordship. We filed petition, we filed contempt, and because of that, the posts were upgraded. The remaining 5 posts. We approached this court several times. The petitioners' groups also approached several times, and in all those things, we were mid parties.
So that's
Then
fine.
associations also came.
That may be history. Now what do you want to say by saying all these things?
Your Lordship, if this is to be remanded, then all those has to be examined and then decided first, because those are also part of our objections in our affidavit. If we are to go into the merits of the case. But then, before further proceeding now, the appellant has to satisfy this court that they have locus and that there is no delay. Now, delays they have admitted. They have not denied. Locus also, they have not denied. They have not denied that we were appointed against direct recruit post. And they are promoters. Nobody is disputing about that. And there is no violation of their legal rights. That is also a part of the locus. Where is their grievance? What legal rights have been violated by our appointment, by our regularization or confirmation? We also have already been confirmed. At least 2 posts of the respondents, 10, 11, they are still on contract, and their post has been requisitioned. And there is no legal, no legal rights of the petitioners have been infringed.
What is the next promotion?
Your Lordship?
Next promotion from?
Next promotion will be DPO, District Project Officers.
See, they didn't have any problem in your regularization at first. But now when the seniority list came, then they found that they have.
No, Your Lordship.
So that is why the cause of action arose when.
Your
Cause of action basically has arisen when the seniority list was published.
No, Your Lordship, to my
Because
understanding.
it's affected then only.
No, Your Lordship. No, sorry. But no. Because we were serving as class 2 gazetted, class 1 gazetted. They were serving as class 2 gazetted. Then, how they can challenge the class 1 gazetted seniority?
No, but
One is lower grade.
You are in the same seniority list.
That is not the seniority list, Your Lordship. That's what I'm saying.
It's a continuous
That's what I try to point out.
Tentative.
That was,
Where is the final seniority?
Your Lordship, may I kindly say again, page 198.
No, that's a
No, that is
seniority list.
tentative. Where is the final?
This is not tentative, Your Lordship. This is a tentative prepared by the additional director submitting to the government to look into it. And after that, they will publish a tentative seniority list, calling for objections.
Whether seniority list
That
has
was
been
not done.
published or not?
No.
Yes, yes. Milord, page number 257.
Plus two,
I've
plus
shown it.
list, I'm referring to plus two at page 198.
Yes.
This is not published. This is communication between the departments only.
No, what about
257.
257.
This is submission of inter se seniority list of both officers and ministerial staffs of social welfare department.
257.
So this looks like a final seniority list. It doesn't
Your
say,
Lordship,
it
this
doesn't
is,
say provisional or tentative.
Your Lordship, this is interseniority, correct? But this includes both class 1 gazette and class 2 gazette combined, not separately. Because DPO is above CDPO.
They have not challenged this. They have not challenged this. So shall we? It's your lecture, so you have no challenge.
One is director. In this seniority list,
It has been shown from the with the hierarchy.
from the top, yes.
It's shown from the hierarchy.
Yes.
So that is
And
why.
then comes CDPO, DPO, DWO, and then come CDPOs. After DWO, Assistant Director, DPO, Assistant Director, then comes CDPO, all CDPO. Then comes Probation Officer, Superintendent. These are all class 1 gazetted now. Probation, Superintendent.
So this is the list because of which, I mean, the cause of action is risen
comes-
according to them.
From
They have not challenged this in the petition.
No, they are not challenging
Why
them.
should I challenge?
They got a grave.
No.
The seniority got
From-
hampered.
Your Lordship, from serial number 80, this senior supervisor starts, class 2 gazetted. I'm sorry, not from 80, from 72. Senior supervisor, class 2. And the rest, class 2, senior supervisor, this is after upgradation. So in this seniority list, they were all serving as senior supervisors. And the petitioner number 1 starts from serial number 89. And the peculiar circumstances, strange circumstances is that just above the present appellant petitioner number 1 at 89, the above candidates, they were initially all appointed on contract as supervisors. And they were placed above the present appellants, petitioners. They have not challenged. Even in the grade of category of class 2 gazetted, these contract appointed supervisors were placed above the present appellants petitioners. They have not challenged that one. They were in the same category. Now they're challenging our appointments in a different category, in a higher category. And the ground for challenging our appointment is that they have future scope of promotion, even to reach the highest post, director. That is a chance of promotion. But for them, it is not possible because they are promotees. They may go later on.
So
but
your
not-
submission is that there no fundamental right has been violated.
No, Your Lordship, no fundamental rights. No rights has been abridged by our appointment and regularization. And admittedly, because this appeal also is not maintainable because of they have not satisfied the court. How there
But
is
the-
locus
these,
standi.
these questions were not gone into by the learned single judge.
Your Lordship, recourse, everything is placed before, whatever is here is placed before the learned single judge. Out of that, he has come to this conclusion. And if a petition is not maintainable
impute
at the
judgment-
outset,
The judgment does not reflect much of a discussion on all decisions.
yes, but
To come to a conclusion that there was delay, to come to a conclusion that there is no.
true, Your
trust.
Lordship,
So there was not much discussion on that, detailed discussion.
Your
on that.
Lordship, there
So-
also,
Of the facts have been placed, then
Your
suddenly has
Lordship.
come to a conclusion.
but there are also decisions, Supreme Court decision that when there is delay or when there is no locus standi, the court needn't go into the merits.
No, merits I'm talking about. I'm not talking about the merits.
And
I'm talking
the-
about to coming to the conclusion that there was delay, that there was no locus standi. Sufficient, I mean, in our view, sufficient discussion was not there.
So the impugned judgment, it is not the lengthy one, but it is precise. And there is no illegality. Yeah. It's okay. Yeah. Oh. Your Lordship allowed me to submit a
No, Mr. Iralu,
decision, yes.
the learned senior counsel for the appellant has made an alternative submission that the matter may also be remanded. Remanded
Yeah.
as the contentions raised by the parties were not discussed, merit was not discussed. What is your submission to that?
Your Lordship, my humble submission is that since very clearly the learned single judge has come to the conclusion that there is delay and the petitioner has no standing.
So
On that points, on that grounds, and on those findings, the learned single judge has dismissed the petition, and rightly so,
okay, so your submission is that appeal should be dismissed.
Your Lordship. And in that connection, I may be allowed to place decision in the case of Mukul Saikia and others, 2009 SCC regarding locus, paragraph Paragraph 40. Copy. Paragraph 40. In the circumstances and the facts of the present case, the appellant cannot maintain any claim whatsoever in respect of the 18 vacancies of CTPOs against which the private respondents were regularized. The appellants and the private respondents stand on a completely different footing. The services of the private respondents have been regularized against the vacancies meant for promotees, and the source of legal right of the appellants and the private respondents being from two different and distinct sources, their relative rights cannot be compared with each other, and therefore there cannot be any violation of fundamental rights under Article 14 of the Constitution of India as a consequence of the regularization of the services of the respondents. And 47. In the circumstances, the High Court is right in holding that the appellants have no locus standi to challenge the regularization of private respondents against the vacancies meant for the promotional quota. The appellants who appeared in the interview held by APSC as direct candidates could not have any grievance against their regularization against 40% promotional quota. And I may be allowed to refer to this is, we have already referred to this one, but on the question of delay. I'm relying on paragraph 9 to 13, but the most relevant is paragraph 11. To cut short the time also, I will refer only paragraph 11. For filing of a writ petition, there is no doubt, for filing of a writ petition, there is no doubt that no fixed period of limitation is prescribed. However, when the extraordinary jurisdiction of the writ court is invoked, it has to be seen as to whether, within a reasonable time, same has been invoked, and even submitting of memorials would not revive the dead course of action or resurrect the course of action which has had a natural death. In such circumstances, on the ground of delay and ledgers alone, the appeal ought to be dismissed or the applicant ought to be non-suited. If it is found that the writ petitioner is guilty of delay and ledgers, the High Court ought to dismiss the petition on that sole ground itself, inasmuch as the writ courts are not to indulge in permitting such indolent litigant to take advantage of his own wrong. It is true that there cannot be any waiver of fundamental right, but while exercising discretionary jurisdiction under Article 226, the High Court will have to necessarily take into consideration the delay and ledgers on the part of the applicant in approaching a writ court. And I'll also refer to 2006 for GLT, paragraph 6 and 7. Paragraph 6 and 7. The order of Lordship has got it.
Yes.
Paragraph 6 and 7. Sixth, the order of appointment of a person against a post can be challenged by a person who can claim appointment against the said post. A person who is not qualified to be appointed and who did not apply for the post cannot challenge the appointment of any person against the said post. The person who challenges an order of appointment of another person by filing a writ petition must therefore be a person aggrieved by such appointment. 7. A person can be said to be a person aggrieved by the action of the government in appointing another person in a post if that action deprives that other person from his right to be considered for appointment against the said post. The petitioners to maintain a writ petition challenging an appointment of another person must show what legal right of theirs has been violated by the action of the respondent in making such appointment. A person aggrieved is a person who has a genuine grievance against an order which has prejudicially affected his rights and interests. A person who is not directly and immediately affected by an order of appointment, but remotely affected or instance of promotion in future has to be affected by such appointment. Not maintain a writ petition. The appointment challenge the appointment of another person as such person cannot be termed as person aggrieved to maintain such writ petition. The jurisdiction of the writ court being equitable and discretionary, it will not issue any writ quashing the appointment of a person on the basis of the writ petition filed by a person in whose favor no relief can be granted. Therefore, Your Lordship,
Okay.
the petition deserves to be appealed, is deserved to be dismissed. This is my humble submission, Lordship.
I'll just give a short 5 minutes reply, my lord. I'm sorry for detaining your lordships. First
Mr.
of all, my
Chaudhary.
lord, yes, my lord.
Sorry, Your Lordship.
Which legal right of yours have been violated?
Yes, I'm coming to that. Yes.
putting you
The
below-
legal right flowing from Article 14 and 16 to have the seniority fixed in the cadre. My lord, let me first point out, my learned friend Iralu has pointed out that we are promotee and they are direct recruit. My lord, it's not a case of rota and quota. There's a concept of rota and quota in service jurisprudence, my lord. It is not a case of quota and rota. There is no dispute, my lord, that the tentative seniority list was published in 2018. Before that, in 2017, my lord, we are upgraded to class 2. So therefore, there was no dispute that we are in class 2. And it is not a correct statement of fact. When
Mr.
we are in class
Chaudhary,
2,
it seems your video is not on.
Oh, I'm sorry. Yes, I'm sorry, brother. My lord, my friend, Mr. Iralu has made a submission that it's a case, we are promotee, they are direct recruits. Therefore, there cannot be any question of any legal right being violated. That is not correct for the simple reason, my lord. By virtue of the upgradation in 2017 itself, we are all in class 2. Maybe by different name. Somebody is a supervisor class 2, somebody is my lord CDPO, somebody is a research officer, somebody is a program officer. So there's no difficulty. Now, my lord, the moment we are all in class 2, then if I find that somebody who is above me has entered service not in accordance with the rules, why I do not have a right to raise a grievance? And that is my legal right. My legal right is to have my seniority fixed above him. That is my legal right. Therefore, my lord, to say that he was not in, when we were in class 2, he was also in class 2, my lord. Tentative senior, the upgradation was in 2017, tentative seniority list in 2018, final seniority list in 2020. We filed the writ petition is 2019. I fail to understand, my lord, where is the learned single judge misconstrued the whole thing by thinking that they became, my lord, contractual CDPO in Milord 2015 to 2016 or 17, and we were then CDPO. That is the concept. That is wrong. With all respect, Milord. It's a pure and simple case. In 2017, we are all together. Then, Milord, we have entered a cadre called class 2. Now, question is, when I have entered class 2 legally and somebody has entered class 2 illegally, have I got no right to question? And Milord, the government of Nagaland has issued so many office memorandum whereby contractual appointment was prohibited. Kindly see, Milord, I have annexed all these documents, Milord.
No, how you would be affected?
I would be affected, Milord, because if the seniority is fixed above me, then my right, my condition of service would be violated.
What condition?
Condition of service, seniority is a condition of service. Well, right to be considered for promotion, right to get pension, right to get increment, these are all conditions of service.
No, but right to get pension is not affected by your position.
No, I am not saying, I am giving an example. Lordship has posed a question, what is condition of service? Condition of
No,
service
but I
include
think
everything, Milord. No,
what
Milord, question.
next promotion to which you would have been
No,
entitled.
I think now, thereafter the district officer, then deputy director, then director, all these posts are there. And immediately, my lord, to class 1, which we are all now. We are all in class 1. So, my lord, to say that it is that we were promoting, no, my lord, the moment we became, my lord, we were upgraded, that question of promoting and direct recruit loses its significance. So then on, and that's why, my lord, they brought out a tentative seniority list. Then we objected. Then, my lord, we filed the writ petition in 2019 itself, where we challenge everything, including the seniority list. And therefore, and my lord, the Mukul Saikia's case, that 2009, which has been placed by my learned friend, kindly see the facts of that case, my lord. That is absolutely distinguishable, my lord. That was a case, my lord. There were some CDPOs who wanted to, my lord, have the seniority fixed in the quota outside their quota. That is not the case here. If your lordship, I don't remember exactly, I think paragraph 34 to 39 of the Mukul Saikia's case, my lord, lay bare the distinguishing facts. Mukul Saikia is, of course, a case from Assam High Court, my lord, and it was with something to do with CDPO. There, my lord, the prayer for seniority was discarded on different ground. Unlike here, my lord, where they were, my lord, irregularly regularized. Okay. Therefore, my humble submission is, my lord, and the latest single judge has not even discussed anything. And Mukul Saikia's case is not applicable. This is distinguishable, my lord.
Okay.
Pardon me, my lord. I'll be allowed to submit a written, a gist of written submission.
Yes, you may submit.
Lordship?
You may submit within how many days? How
2
much?
days.
Yes,
If
yes.
possible, I will give tomorrow. as well.
Yes, yes,
If not, day after.
yes.
It's got a copy to her also.
Heard Mr. K. N. Chaudhary, the learned senior counsel, assisted by Ms. V. Zimomi, learned counsel for the appellants. Also heard Ms.
2 and 3. And Mosoi.
Mr. N. Muzoi, learned government counsel.
No, Lordship, I have engaged counsel.
Learned counsel appearing for respondent number 2 and 3, as well as Mr. R. Iralu, learned senior counsel assisted by Mr. L. Iralu, learned counsel for respondent private
4 to 11.
learned counsel for respondent number 4 to 11. Hearing concluded, judgment reserved. The learned senior counsel for the private respondent number 4 to 11 is allowed to submit a written gist of his argument within 2 days from the date of this order.
Leftover, sometimes discretion is given to the court master, give a date, cancellation.
So I have 4 weeks ago, to one spot. I think for 2 days. I can put one.
Keep him out.
Next week. Next week. Next week. Next week. Next week.
Yeah. How? Where?